Good morning, guys. How is everybody? I hope you had a good New Year's. Um, we we didn't do anything really. Travis found some old firecrackers. Oh, dang it. Um, we I was on YouTube most of the day. Recovery Addict had an year-end celebration award show kind of review thing, like where people sent in um nominated different best of type things, and we went through some of the old cases and like the funny parts of old cases and stuff. And then Ada K did like just New Year's celebration, like for every time zone. She started early in the morning, and so I was on hers, and I was on RA. Then I jumped back to her. Then I went to um Biggin. He streamed at 6. American Court streamed at 8. And I went back to 8K. So I was just doing YouTube all day long. And then at 11, I'm like, okay, I'm gonna go spend the last hour of the year with my husband. So I go in there. He's watching football, and I'm like, "Are we gonna watch?" Because every year we watch fireworks on TV. I was like, "Are we gonna watch fireworks?" He's like, "It's not time yet." I'm like, "Okay." So I came back to the computer. I'm like, "He says it's not time yet." So I just stayed on there. So then he goes outside with the firecrackers, and we've got like, let's see. I took a picture of it to send to somebody to show what he did. Because we have this like lattice work outside. You see like the little that little space right there. He stuck the firecracker in that. So that's like right outside the front door. And I walked out right as it exploded. Scared the mess out of me and the dogs because the door was open when it did. I said, "Oh, that's it. I'm done." If I had been like out in the yard when it went off, I would have been, "Oh, cool. Let's keep going." But no. Yeah, curly Q. Yeah. Was like, that was loud. Actually, that's why Belle is afraid of loud noises, because when she was a puppy, we got her. When did we get her? March? April? April, maybe. No. We got her right before my dad died. Well, maybe. Dad died. Dad died at the end of April, and we got her right before he died. So April, I guess. So she was still a puppy, 4th of July, and she was out there running around, and we were doing fireworks on 4th of July, and I guess I lost track of her, and she was too close to the firecracker when it went off. So she's been afraid of loud noises her entire life because of that. Um, so I opened the door, and you know how dogs are. They're wherever you are. I actually didn't see them, but I realized after it popped, the dogs were nowhere. They ran back in the bedroom because they were like, I don't want any of that. So then he came back in, and we watched the ball drop on Ada K's for ours because she was doing each time zone. And then he went to bed, and I stayed up because Ada K's in Texas. So I stayed up for her time zone. And I think I went to bed a little after 1:15 or something. So that was it. Not very exciting. I keep saying, yeah, I'm old. Like there have been, I think last year I stayed up till midnight. Year before I didn't make it. I think I fell asleep, got waiting because I just couldn't stay up. But yeah, when you get to be in your 50s, it's not, I mean, it's kind of cool to still stay up, but it's like you don't go out and party and do all those kind of things anymore. It's just not a thing. So, Nancy, did you go to the doctor? I don't even have, can you guys hear me? I didn't even have my mic over here. I'm sorry. Nancy, did you go to the doctor? Or are you better without having gone to the doctor? You scared me the other night. Like, well, if I'm still here tomorrow, I'll go to the doctor. That's not how that works. You go before you feel like you're going to not be here. Okay. Good news, bad news. I signed up for the new internet. I'm all ready to go when they come out to install it, but they can't get out here till February 6th. Okay, cool. I'm glad. Yeah, that's what sucks. Like, there's no cure for the common cold. It's ridiculous. With everything else we have that we can cure, and the cold is just, nope, just wait it out. So internet won't be set up until February 6th. I guess because it's still new, that there must be a long line of people waiting to get on it. So that's why it's taken so long. Because we've been waiting for this new internet. See, I thought I had really good internet until Brian informed me otherwise. So I wasn't even going to switch. Because I mean, I'm still of the opinion that it's StreamYard's fault because I didn't have trouble until just recently. But so I wasn't even going to look into the new internet, but I did. And when I did, I was like, oh, holy crap, I can get way better speeds at a less, and a much cheaper price. So, but yeah, it's going to not be till February. So I might have to turn my camera off again. When I was on, because Ada K had the StreamYard link up, and I tried to get on there with her, and even like late at night. Well, it was New Year's Eve though, and people stay up later on New Year's Eve. So, but late at night trying to get on with her, it was choppy and bad, and I'd have to keep getting off because even with me not talking, I would miss stuff that they were saying. So I was like, okay, no, I got to get off of here because I'm missing stuff. So I'm just going to, be in the chat, and so I could hear what you guys are saying. Okay, so I showed you guys the elevator video of my mind just went blank. Courtney Clenney and Christian Obumselli. Obumselli, how you say his name? Obumselli. I found the other one. I think it's the other one. The one where they're like on vacation somewhere and he just smiled at another girl or said hi to another girl or something, and she went off on him. So I found that one. So I'll show you guys that one. And let me know what you think. Of course I'm going to ask, Nancy. You scared me the other night. You scared me. And then you didn't say anything else. And I was like, Nancy, talk to me. This is another one of those court TV things where I'm going to have to fast forward through them talking, I believe. The other two hearings, they're law and crime. So hopefully, I'm not monetized, so I don't think that law and crime is going to give me a hard time. They're probably not going to mess with me until I get monetized.
The video was shot in Aspen, Colorado. Colorado in 2022. 22.
For crying out loud. You're hindering my process.
I need to sit down.
Let go of me. Yes. Let go of me.
Come on.
Let go of me.
Okay.
Come on, boy. Let go of me.
You don't want to hit me?
I'm fed up with you. I'm fed up. I'm fed up that you
Courtney,
oh, yes, I'm not mad at you.
You let Moana say some line that affected you.
I didn't let her say anything.
I didn't say
you did.
Hey, we're
Here we go again. But he's not hitting her. He's grabbing her arms to stop her from hitting him. She's the one doing all the hitting.
let's not say anything.
Okay,
Come on. Ask her. Ask her, did I touch her breast yesterday?
Instigated fears.
No, you're telling me I touched her breast yesterday when I.
You did. I didn't say.
You said I did.
You were leaning. Yo, you were dumb. No.
Yeah.
Actually, dumb.
Okay, fine.
Dumb. Because you're costing me money. I didn't do. He's like, I'm just flirting. Like 3 girls the whole time.
What 3 girls? What 3 girls? You?
Well, maybe
You?
matter.
Milan? I was flirting with Milan.
She said, hey, come here. She's trying to come home with me.
You're lying.
No, I'm not.
You're lying. She said, come get your man that I was trying to hit on Milan. Come on, baby.
Okay,
that doesn't make sound right.
Christian, you're fired.
It's fine.
Hopefully, shut up.
You never see me again. You are the most
good taste. Shut up.
Ever met in my life. You Courtney.
Dude, get the out of here. Just leave your house.
Yeah, cool.
It's not my house. Like, you're just like my boyfriend. Get the out of here.
Just like your boyfriend?
I can actually get like down if you're not here.
Yeah.
Get the out of here.
Okay, I'll remember that next time.
Get out. No, not even next time. Get the Get out.
Don't touch me again.
Good thing, get out, bitch. Get out.
Bitch.
You never loved me. The way you talk, the way you treated the girls, the way you embarrassed me. I don't want anything to do with you.
I embarrassed you yesterday. You're really just self-conscious. You always talk about, oh, Christian, you like this. I say, what did I tell you before? You're the baddest person in this bitch. No one has anything on you. I tell you this every day. I have text messages that you say, Christian, thank you for the content.
Shut up! But you don't do it the next day!
Why are you screaming? There's people in this house.
Get out, for real. I never want to see you again.
Cool.
So difficult to watch those young people struggle.
I want to know why they had their friend or whoever that was film that. Like, they knew he was filming it. Because she turns and talks to him. What? Why? That's the last thing I want to do. If I'm having Travis and I don't fight. But if I was having a fight with Travis, that would be the last thing I would want. Is for someone to be recording it. I mean, that's crazy. That's one thing I don't understand. Like, I get the elevator video because elevators have cameras in them, but why was their friends recording their fight? Okay, so I found another. Do you remember that hearing that I wanted to do? And I guess I got the date wrong. It still said the date that I thought it was supposed to be. That was the date on the docket. But I don't know what happened. But there was, I think, this says it was like 2 weeks ago. But let's do the one that was like 2 months ago that had the knife throwing demonstration. And then because it's a shorter one than the other ones that we watched, and then we'll do the one that was like 2 weeks ago. Because both of those together are maybe as long as the ones that we've been doing, like the 4-hour ones. I'm going to turn my camera off again. Oh, dang it. I pushed the wrong button. Come on, internet. You can do it. See, if I wasn't watching this in StreamYard, it would just pop right up. Dang, I hit the wrong button again. I blame the fact that I haven't had my protein shake today. I murdered 2 blenders this morning. I killed 2 blenders today. I killed my blender and my husband's brand new blender that I got him for Christmas. I haven't told him yet. He's going to kill me.
Everybody ready to go?
Good morning, this is Courtney Clenney, Kathleen Hope, and Sean Abraham from the board.
Good afternoon, Your Honor. Chief Prosecutor Mickey Radson on behalf of Tim and Deborah Clenney for the presence before the court.
And we do have Ms. Clenney present on the first hearing as well. So we'll go ahead and get started. Mr. Casciano, my understanding is you want to be heard first on the motion for reconsideration.
Yes, Judge. Thank you. I appreciate you accommodating me. I know we've got a lot of attorneys and moving parts, so just so we weren't getting in the way of everybody's schedule and we're trying to squeeze a couple things in. So thank you.
I will allow you to argue it briefly, but I did read through it. I read through the civil case that you decided. I think there's enough. I guess we have yesterday that you already.
So thank you.
Well, it looks like
Yes, Judge. I appreciate
I
that.
can't get closed captions on it anyways.
I will keep it brief. I know that motions.
I haven't told him yet, so I don't know if he's mad at me or not.
always the court's favorite. So again,
I hope when it cools down, it'll work again.
I'm hoping to not have to, Judge, but the leading from the court is not going to be able to confidence. So let me do my best, Judge, if I may. And again, we appreciate that. So part of the reason why the court doesn't really see any criminal cases because it's a civil rule procedure and generally it applies to, as the court pointed out last time, physical property. We're talking about data here, which I think is a pretty unique issue. Here's where the issue on intervention, I think the problem is with the court's analysis. We've all agreed, and that's a rarity, especially in these cases, for us to have an agreement, is that the plain language of the rule governs. The court, in its denial of our motion, employed this two-pronged test. I don't read the rule that way. The rule says that the intervention shall be in subordination to the main interest, and we can concede that the interest we're discussing is the state's right to investigate and prosecute Courtney Clenney. There is nothing in the plain language of the rule that precludes the intervention based upon the intervener's status. So we disagree with this two-pronged analysis. But let me say this, Judge, because I do have a duty to be candid to the court, and if the court retains its position, yes, it is our intention to seek a review of it. So I think it's important that I point out that in my review of the case law, even if
You're close up.
I'm correct, which I may not be, the appellate courts will still look to the more substantive issue and consider the court's ruling on the intervention itself to essentially be a harmless error. It's kind of akin to a tipsy coachman analysis. So I think the bigger issue and the better use of my limited time is to discuss that issue of subordination. And I think I did the court a disservice at the last hearing because I did not draw enough attention to the Florida Constitution, in particular Article 1, Section 23, which is, as Your Honor knows, the section of the Florida Constitution that in its own right creates a privacy interest. That is unique, and just again, Judge, for purposes of the record.
Because I do think that it is an issue that is more, well,
Okay, so Judge, again, because we are talking to the record now, let me just be sure that, yeah, so let me cite to Article 1, Section 23, right of privacy. Every natural person has the right to be let alone and free from governmental intrusion into a person's private life, except as otherwise provided herein. This section shall not be construed to limit public's right to access to public records. More importantly, Judge, I'm going to cite the court, and I know Your Honor did read our pleading, but Winfield v. Division of Power Mutual Wagering, which is 477 Southern 2nd 554. It's a Florida Supreme Court case that discusses Florida's unique privacy right and its unique interest in the Florida Constitution. This is, and I'm quoting now, Judge, this amendment is independent, freestanding constitutional provision which declares a fundamental right to privacy. Article 1, Section 23 was intentionally phrased in strong terms. The drafters of the amendment rejected the use of words unreasonable or unwarranted before the phrase of governmental intrusion in order to make the privacy right as strong as possible. And that's why I'm back before Your Honor, because I'm having trouble understanding how the court is reconciling the warrant as it is with Kim and Deborah Clenney's very, very robust privacy interest. I will concede, Judge, the state has an interest, and not a small interest either, Judge, in prosecuting Ms. Courtney Clenney. Kim and Deborah Clenney are not charged with a crime. The reason their data is even subject to that interest is because they are related to someone charged with a crime. Florida's constitutional amendment protecting privacy doesn't allow for that. Now, there is a compromise, Judge, and there is a way that this court, with its jurisdiction, can address this issue. So, again, as I was saying, I was having trouble reconciling the denial and the data that's in the court file with that constitutional amendment. However, given the breadth, both in scope and time of the warrant itself, I think it's incumbent upon the court, in consideration of Article 1, Section 23, to narrow that. And let me put a finer point on that argument, Judge. The state has pointed to 3 separate instances what they think they are going to find in this data and why it is relevant to the prosecution of Courtney Clenney and why they should be allowed to go through 3 years of iCloud data of 2 private citizens uncharged for the crime. First, they say that Deborah Clenney may have been on the phone with Courtney at the time of or in close proximity to the death of Obumselli. I'll concede that point, Judge. If it's true and the state can support that in an affidavit, then we know when the death happened. A narrowly tailored search warrant or subpoena for that data is perfectly appropriate. The second issue, they pointed to photographs that were voluntarily turned over to the state to show the abuse by Christian Obumselli of Courtney, and have argued that there are gaps in the images. Again, the time, we know when that happened, easily searched, easily collected, and certainly within their interest to prosecute this offense. And the third argument that was made by Mr. Quinnan at the last hearing, and that we've heard before, is that Kim Clenney in the Arthur hearing testified to something about commingling of assets, and Mr. Quinnan's exact argument to the court at the last hearing was that, and this is I think on page 29 of the transcript, Judge, that was indicia of risk of flight. Okay, here's the question for that. The Arthur hearing took place in November of 2022. Why would Mr. Clenney's testimony and the state's concern of risk of flight after Your Honor pretrial detained in court be relevant to a warrant that was issued a year later? That begs the question of the legitimacy of looking for. Let's assume in argument that those points are all needed and they're essential to their job to prosecute this case. Very easily, narrowly tailored. There's no reason why Mr. Clenney is saying that there may be commingling of assets should open up his financial records from 2-3 years prior. Should allow the state to look into medical records or private photographs or private spousal communication. And what's preventing them, and what I'm arguing to Your Honor, and again asking you to reconsider the position and find that compromise, is that Florida specifically tells you they can't. The constitutional amendment is there for a reason. Not every state has a specifically enumerated right to privacy. Florida not only has one, but an incredibly robust one, telling this court, government, but that interest need does not trump a constitutional right. So you have the answer, Judge, and that's what we're asking the court to do, is to say to the state, hey, you don't need Mr. Clenney's medical records from 2020. You don't need Deborah Clenney's photographs from 2021. These are the things you told me you're looking for. Bring me a more narrowly tailored affidavit and warrant, and I will review it and sign it if it's appropriate. That is the compromise, Judge, that allows the court to exist between the state's interest in prosecuting the case and Kim and Deborah Clenney's extremely robust privacy right.
Judge, I don't have significant more argument on the court. Precise question. I would point the court to the rule of motion.
I had to step away because I had to go tuck Spike in. Is that her parents' attorney? Because I haven't seen that attorney before. Is that her attorney or her parents' attorney?
For rehearing, the rule specifically provides that the motion be filed in 10 days. The motion was filed in 16 days, so it's time barred from rehearing on the court matter. And as it pertains to the constitutional argument, I agree that the Florida Constitution provides the right to privacy. Section 12 also allows the state to apply for warrants, which we already have done. Mr. Patridomo's recommendation of a compromise express to do something we have already done was obtain a warrant and support by
again, the only thing that is cited in your motion, are civil cases. This is not a civil case, this is a criminal case. I did my own research, I could find absolutely nothing that is analogous here, and I think that there's a reason for that. I don't want to be the one to set the precedent for looking through every single search warrant that comes before me, because somebody is going to put forward the right to privacy. That would exist in every single search warrant for every single thing that the state gets a warrant for. Listen, if the third overturns me, great, they overturn me. Let them do that balancing test between constitutional right to privacy and the right of the state to pursue its investigation and its warrants. I'm not going to be the one to set that precedent. I don't think that is my job. I don't think that you have the right to intervene. You have an interest in the case, but I do not think you have a right to intervene. I did all of my own case law research on this. The only thing that I found were victims who were coming forward intervening in cases because there was a violation of Marxist law. This is not this. They are not victims in this case. If the third wants to carve out its own balancing test between the constitutional right to privacy and a judge determining what parts of what was already determined to be a valid search warrant that was drafted by Judge Wilson. If the third wants to do that, they can do that. I am not saying that precedent. Okay, so.
Thank you, Judge. Just to clarify one point, so the court does have that responsibility under 933 to review each of those warrants, and Judge Wilson actually renewed Judge Cabargo's warrant. So, just
at this point in time, there was already a warrant that was filed for probable cause. There is a privacy interest everywhere. I'm sticking with my original ruling. I think that it is the correct ruling. I think that I used the correct common test. Again, I can find nothing analogous, and I think there's a reason for that. However, if the third, if you want to take it up to the third, I know that this is a final order and it's reviewable as of this moment.
okay, so this is the court's order orally pronounced.
Yes.
Thank you.
Okay, and if you want to, I can do a free, I'll do a free order saying that it's denied, and I will incorporate by reference the transcript for the case. Okay?
Thank you.
All right, thank you. Let's move on to this motion to resolve.
Now that is what a tailored suit looks like. Look at how that suit fits that man. I have never seen a suit that looked that tailored before. You can tell that did not come off a rack.
Yes, good morning. Good afternoon, Judge. Frank Dover, this is 22-14137 case along with my co-counsel, Ms. Selena Puglisi.
Cameraman.
Okay, so next up then.
Good Lord. What is wrong with this cameraman?
I'll be real brief. I tend to agree with the statement that there's no basis for a dissolution. However, I'm going to treat it as a motion for consideration.
Cameraman is fired. I hope this is not the same cameraman that does the trial.
947.0416 section.
Fired.
A versus N. I don't think that there's anything in the motion that talks about a subsequent event.
Oh my God.
Which is subsequent event, there's not one. But you do talk a lot about why I should reconsider it based upon evidence that was unknown at the time of both the Arthur hearing and the confidential motion. There is no discussion of the Arthur hearing in your motion to dissolve. I mean, I did make a finding based on the Florida Constitution Arthur hearing as well as a pre-trial detention statute. So even if I were to reconsider the pre-trial detention statute, are you also asking me to reconsider the Arthur hearing ruling?
Judge, the
Hey,
rule
Arlo.
to take into consideration of 3.132 subsequent events. I hear what Your Honor is saying,
Well,
but
first of all,
we
are
do
you
have.
also asking for me to reconsider the Arthur hearing ruling?
Judge, we know that you made a finding of proof evidence presumption great, but the phase 2 arguments are what we're readdressing, which is permitted under the bond statute 3.131 and 3.132 sub-state.
Okay, so you are asking for me to reconsider the
Just the part of Your Honor's ruling that coincides with Your Honor's ruling under 3.132 child detention, because there are those two, Arthur and those obviously already done.
Okay, so what's your subsequent event that you think that it qualifies as for dissolution?
Sure.
Subsection N?
There's several subsequent events. The term subsequent event is not defined in the rule, but there are subsequent events such as the discovery of the body on camera of an eyewitness showing the abuse in his funny face. That is a subsequent event that presenting that to the court, finding on discovery.
Listing if that's evidence that was unknown at the time of the hearing.
Correct, but I believe that's an event. I don't know how you're defining event. I think that qualifies as an event, along with the listing of expert witnesses in this matter. Your Honor, to consider, I think.
Listing of expert witnesses is a subsequent event.
The discovery from the expert witnesses, their belief.
That's a subsequent event.
Yes, Judge, specifically, you are finding there's a substantial probability that she committed the crime, okay? And what we are showing the court is that she's justified in her actions when she acted in self-defense. Now, we made that argument at the initial hearing and then detention hearing, and the court said that you didn't find there was sufficient evidence to believe that. We now have sufficient evidence, which is a subsequent event, and that's what we believe, because there's no case law to really, there's no definition in the rule that tells you what subsequent event is. So we do believe that that falls under subsequent event.
I'm gonna let the state address that.
So Judge, for one, I do not believe the state will stand on the premise that is not a subsequent event, an event that the defense is creating. And in this specific case, it's an experiment created by the defense to throw knives at a pig carcass. To create the general premise that it is possible that this defendant could have thrown this knife. So one, the factual scenario itself would not rise to really a consideration against the dangerousness of the act itself. But even then, the subsequent event, that isn't a subsequent event. They've created a circumstance that isn't factually supported by any of the evidence in this
Let me
case.
give you a definition of subsequent event. Subsequent event is if you have victims who are living near, in the country and then move abroad. And that moving abroad means that the person's not a danger to those particular people. That's a subsequent event. Somebody getting a terminal illness and or becoming paraplegic and therefore not being able to travel, that's a subsequent event. Discovery issues and the hiring of expert witnesses, that's not a subsequent event. You can go to motion for reconsideration. That's why there are two prongs in the statute: reconsideration and dissolution. Dissolution means it should be dissolved because, in quote unquote, let me go to subsection, what is it, N? Because the subsequent event has eliminated the basis for detention. That's not what any of these are. Okay, so that's not what this is. What you're asking for is reconsideration. Your creation of a video from an expert witness, or your discovery of the body-worn camera for somebody that you didn't know existed at the time of the pretrial detention motion, although I know that it existed, but maybe you had seen body-worn camera, none of that is a subsequent event.
Yeah, I meant to mention at the beginning that we need to keep, I totally forgot about it, but I was going to mention it. We need to keep the people in New Orleans, Nolans. We need to keep them in our thoughts and prayers. From what I understand, because the bodies were beyond help, that they were just left in the street so they could process the crime scene. And so because of the time of year and everything, there were tourists there in hotels on Bourbon Street, and they could just look down and see everything. And so not only do we have lost loved ones and injured people, but then you have traumatized tourists that were in the hotels. I mean, that's like a tourist street. That would be like if there were dead people on Main Street in Disney World. You know what I mean? Like, it's horrible. And there was another terrorist attack. Somebody drove a car into one of Trump's towers. I don't remember which one it was, because he has several all over the country in different places. And then there was another mass shooting. I think it was in Queens, New York. So I don't know if it's all connected. I think they are connecting the Trump Tower thing with New Orleans, but I don't know if the Queens mass shooting is in with that. So, what? There was something in Las Vegas too? Good Lord. Or was the Trump Tower in Las Vegas? Is that what? The Trump Tower was in Las Vegas? Man. I know that some of y'all don't believe. I know Arto's one of them. Oh, yeah, Cybertruck. Oh, okay, yeah. Oh, okay, it was a hotel. Trump Tower. Oh, Trump Tower in Vegas. Okay, yeah. So like I said, I know that I believe the Bible. I know. Well, Arto, you've read the Bible. We're living in the end times. Hey, just because, yeah, we're living in the end times. Whether you believe in the Bible or not, I believe it. We are living in the end times. Okay. All right. Just keep them in your thoughts and prayers or whatever, because, yeah, Happy New Year. Okay, let's get back to it.
So, nothing that is the basis, and I went through your entire motion, nothing is a subsequent event. Reconsideration.
I'm going to try to make it big again if
Okay.
StreamYard will cooperate.
None of those are subsequent events. And I'm making the finding that
There we
they're
go.
not subsequent events. Nothing that is listed in your motion is a subsequent event. Okay, so I'm not resolving anything, however, I will reconsider them. Okay, so we're moving on to reconsideration. We can discuss what it is that you believe that I should use now in an analysis for reconsideration, both of my ruling for the Arthur hearing as well as my ruling for the pretrial detention motion.
We have evidence to present judge in the form of Dr. Marichini. I just have to see if he's here because we were set at 1:30 actually for this, so I told him to be here at 1:30. We can go through our other arguments, though, Judge, before we get to that, though. We have other evidence to present.
Yep. 100%. I'm just waiting for Jesus to come back any day now.
The only thing is, I had the whiteboard, he had asked, his courtroom is so like, it's hard to even, I tried to even bring it in, and it's very hard.
What else do we need to know?
Yeah, he's gonna want to use it. I don't know if we'll be able to even fit it in here. Is it possible for him to sit on that chair instead, Judge? Is there a microphone or no?
There's no mic.
Oh, there's no, okay, 'cause I was gonna say.
Oh, that's why the sound is so bad, because there's no mic. And there's no closed caption for some reason.
Yeah.
Sorry, guys.
Should we have some additional evidence to introduce? One is a clip of the video of Dr. Marichini during the demonstration. I believe we sent it to you, right, Judge? Okay, so I was just gonna have him walk through that, what he was doing during it. I'm gonna have to show it on my laptop though, because we don't have a touch screen. So I'll just put it close to him where you can see it as well.
And I will allow you again to show me whatever you want to show as a motion to reconsider my previous decision. I have already looked at most of what you sent, which includes the videos, body camera videos, Chini, and then the microphone guy.
That would be great. All right, I'm done. I'm just, leave it with Dr. Aaron King, who's also next to us.
That's true.
Yes.
So, Judge, the only question I have is the video that Your Honor saw, was it a singular video?
This is the same one here I showed you. Yeah.
So the throwing of the knives towards the puppet.
That was one of them, and the other one was checking.
Okay.
All three videos of body worn, knife throwing, and Dr. Aaron cheating with his.
And we can clip them down.
It's possible. My eyes are overly dilated. I don't know why, but all my life people will look at me and say, "Are you on something?" No, it's just the way my eyes are.
Oh, yeah, it's just we were just called up.
All right, Dr. Mancini, if you could come forward, I'm gonna have you sworn in. Do you have an eraser for the whiteboard?
And I have markers.
You swear from the evidence you're about to give, you stole nothing but stole
But it is extremely possible. She seems to be a high-strung person. She probably needs to be medicated with
Dr.
something.
Marchini, can you, did you introduce yourself to the court already?
No, my name is Dr. John Marchini, MARRACCINI.
Okay, and very briefly, I just want to go over some of your experience as a medical examiner. Let's start just with your education.
Judge, I think we can stipulate to his expertise.
Perfect. Great, okay.
But
So we
why,
would,
Ardo?
have him as an expert in the field of forensic pathology, clinical pathology, and anatomic pathology, in which he works in.
Absolutely agree to do that for all these things.
Great, thank you. Can you tell the court, what you were retained to do in this case?
Simply put, I was asked to investigate and review evidence as to whether a thrown knife, specifically the knife involved in this particular case, could penetrate and inflict a wound found on Mr. Obumselli.
And did you review various documents in, making your determination, prior to making your determination?
Sure, I reviewed the complete work product of the Office of the Medical Examiner, including
I thought they just said there was no mic. There is a mic.
I reviewed the complete work product of the Office of the Medical Examiner.
Oh, interesting.
Limited to the autopsy report, the autopsy photographs, and miscellaneous notes. I reviewed police reports, some police statements, some videos associated with this, and then we conducted some research. I collectively with a knife throwing expert named Bobby Branton, and after the conclusion of these different things and the review of other evidence and statements, I formed an opinion regarding whether the knife could, if thrown, penetrate and inflict a wound as seen on Mr. Obumselli.
Let me ask you this, did you review, crime scene photographs?
Yes, I did.
What about the Arthur hearing transcript of the testimony of Dr. Hutchins, who is the medical examiner for the state?
Yes, I did.
What about the crime scene, the documents including the floor plan, the report and floor plan?
Yes, I reviewed all of those things.
I believe you said the medical records from the trauma center. What about the fire rescue reports?
I did.
Okay. Did you review Ms. Clenney's statement to the police?
Yes.
And did you receive, or did you look at any of the knives in question? And I don't mean the specific knife that was used in this case, I just mean the type of knife.
But I asked if that's deemed the proper and identical weapon, so that weapon could be looked at and tested with. This was done both with myself and with Mr. Branson, and so forth. And then there was some testing, which is from video recording, of the knife being thrown. I made arrangements to select a suitable biologic material. And what we finally settled on was using a side of pork, essentially.
How did you make that determination?
Pardon me?
How did you make a determination to use side of pork?
Well, I wanted the mammalian tissue with skin and muscle and other structures similar to the human body and the general way that we're struck. So we didn't need to go through bone, but we need to have a part of the picture that would have sufficient muscle, fat, fascia, and so forth, with skin.
Now, and I know you're not here qualified as a knife throwing expert. Do you have any experience throwing knives?
Well, I've been an amateur knife thrower for about 30 years.
And did you yourself try to throw these knives in this case?
In that room as much as you say you do.
Now,
You just don't like the
did
door.
you participate in a demonstration that was done with Mr. Branton throwing the knives into the pig carcass?
Yes.
And can you just describe what your role in that was?
It was primarily to determine after the knife was thrown, to examine the penetrating defect and to see if the strength, resiliency, and other features of the tissue was similar to human tissue in the case of where Mr. Obumselli was struck, which was the upper pectoral area and the deeper.
Now, how the demonstration was conducted, and I mean specifically how far distance-wise the knife was thrown, that was something made by the defense, right?
Right, the defense proffered and communicated with Mr. Branton about what they wanted.
And you have no knowledge as to why or how that number was picked.
No,
And I mean, just to be clear, you weren't present on the day of the scene, so you don't have any specific facts about what happened on the night of April 3rd.
well, I only know the facts as collected by crime scene and from other sources, but I was not obviously present.
Okay. So now going back to the demonstration, and what I'm going to do is, I'm going to play it for you. We don't have a TV, so I'm going to bring this to you and say thank you. Yeah. Oh, okay. Okay. Mr. Prieto is going to try to bring the TV in. Okay.
Yeah.
So in the meantime, we'll just keep going. Let me just ask you this. What is your opinion in this case?
That a thrown knife, such as identical to the one used in this particular case to inflict a lethal wound, could have been thrown and inflicted sever.
And when you say could have, can you be more specific as, I mean, can you say percentages? Are you able to do that?
Well, I mean, the simplest way to to divide between whether or not it's directly thrust into someone, using the hand to use a leg or whether it's thrown. If we can use penetration, this particular knife is very sharp. And getting to the skin, it gets to the skin very easily. Most knives only require 6 to 12 pounds of pressure. So, a human being, even average or less than average strength, can easily drive this knife almost 6 inches. But the actual penetration of this one is around 3 inches. So, also there was no hook on it. And so, these values.
Can I stop you for a second, because I didn't hear, I'm sorry, there was no what?
So HILT mark, in other words, when a knife goes completely through to where the handle is, it sometimes leaves an interface mark where the blade meets the handle. That wasn't present. So at the end of the day, I favor it being a thrown knife rather than it being a directly inserted knife as in the usual stab. The difference in penetration, in my mind, is one of the decisive factors that favors one over another.
And what about,
Well, she does know how to work a camera. I mean, that is her profession, by the way. So, yeah, she knows how to look pitiful for a camera, or anyway, whatever way she needs to look for the camera. And what he just said only applies if there's a hilt on the knife or like a big wooden handle. The knives she had didn't have those kind of handles on them. So I don't know that there would be a handle mark. And okay. Those knives were weird looking. Because it was like the knife part was like just like a silver part, and then the handle, like kitchen knives have like a wooden handle that are like a little thicker. She probably is a better actor than Amber. But like a wooden, like, so you've got, I can't do this with my hands. Well, my knives aren't wooden. My knives aren't wooden, they're plastic and they're old and beat up. But like the blade part is thinner. Am I getting in trouble for showing a knife on YouTube? I don't know. See how like it's thin? He's talking about this part. Like, and knives didn't have these kind of handles. They were like just little like flat things that went to nothing. They were almost like the thinness. Oh God, no, they're not. Mine or hers. I don't know what I've never seen knives like that before. They almost didn't look like they had a handle. They were weird looking. So, well, you'll see them in the thing. I don't know that they would have made a mark if she'd stabbed. Also, where she stabbed, the collarbone, I imagine, okay, if he was she stabbed the right shoulder, because I remember they were talking about if it was straight on, she would have had to been offset from him. Right, they do. They do. They don't look like kitchen knives. They're weird looking. So if she got him, so she's right-handed, she got him in the right shoulder. So they might have been like, I don't know, fighting or whatever, and she stabbed. She probably didn't get it all the way down because she probably hit that bone. Because it was behind the collarbone. Your subclavian artery is your clavicle, subclavian. So it probably did hit the bone or scrape the bone and it didn't go all the way down to the mark. I'm sorry. I know I haven't even seen the trial yet. No evidence, no, not a lot of evidence, but I just don't think you can make that by throwing it. I'm with the medical examiner on you throw a knife at somebody, a regular knife, no experience in knife throwing. Oh, the time. What's the time? When are you safe? I'm only an hour in. I don't know if I'm safe or not. See, I'm not monetized yet, so I don't pay enough attention. Maybe I need to start paying attention to that because hopefully I'm just a little over 100 to go because I've got my watch hours now. So I'm a little over 100 to go and I can apply. I guess I need to read all the guideline stuff. I've read it before, but I guess I'm getting close now, so I should read it again. So yeah, he's talking about it making a mark as it goes all the way through. In another part of the body, I would buy that, but where it, like, the bone would have scraped the knife, I'm grossing myself out. Okay.
Slippage where there might be marks on the defendant. That can happen if a person is using a knife, right, to stab somebody?
Right, I mean, a knife that does not have what we call a hilt guard, which is like a cross
Yep.
piece to the blade. It's pretty easy when you drive a knife to, your hand slip up onto the blade edge. It's found.
Did you review the photographs of Ms. Clenney's hands? Okay, and you didn't observe any kind of damage to her hands that would be the result of slippage?
Right, there are no cuts.
What about any defensive wounds? Did you, in your review of the photographs of Mr. Obumselli, did you see any defensive wounds on him?
I did not.
What, if anything, does that tell you?
Well, usually defense against knife, you see some cuts in the hand by the person who is receiving a knife assault with the hand, holding a blade in the surgery. So we just didn't happen to see any in this particular case.
And I know that you wanted the whiteboard for a reason. Was there specific, wanted to show the court something?
Well, I mean, if necessary, unless Your Honor probably gets it, so I probably don't.
Okay, was there something specific?
Well,
Just to make sure she understood.
I would just, show a trajectory of a throw knife just for purposes of discussion. And some other things that might be pertinent to the defense theory.
Okay. What specifically would you think is important for the court to understand that goes towards your opinion in this case?
Well, there was a proffer by defense that at some point in time, there was an altercation needed to proceed the knife event. And that proffer was the defendant was assaulted by means of an arm going across the neck of, and so the question was, from the examination of the neck of the defendant, the photographic evidence in this case that found the defendant.
Judge, at this time, I would, do you have an objection to it? I don't know. Take a look at these two photographs, let me know if you review those.
Yeah, there's another one that's a little better.
I'll show it on, I'm gonna show you on the screen because it actually comes up better than. printed. But you said that you have seen those?
Of course.
Okay. I would move without objection, defendants A1 and A2 for identification into evidence.
A1 will become defense A, A2 will become defense B.
Just can I have a moment and I'm gonna hook it up on the TV here, please?
Ollie, can you move the whiteboard and see that?
Oh, okay.
That whiteboard has seen better days. Shameful. No court can have a whiteboard that bad that you have to use cleaner to wipe the words off of it. They decided not to use it. It was so bad. I guess Sarah Boone used up all of the state's money so they can't afford to buy Miami-Dade a new whiteboard. Good God, what is wrong with this cameraman? Oh my God, who pays $150 for a knife?
I'm showing you, I believe this is it
A1.
A1?
A.
It's defendants A. I'm showing you defendants A. This is one of the photos you said you observed?
Correct.
And what, if anything, do you see from this?
Well, can I step down, Your Honor?
Yes.
I want to know why she's wearing a cross.
All right, well, this particular picture, there's several pictures of the defendant. This is one of many, and some of the other pictures showed it better than this, but there's a faint blue-green discoloration here and some faint reddish discoloration here. And, you know, when we see that, it's not, it doesn't prove it because it's, you know, obviously it's a very fine, but nevertheless, when we consider whether some pressure might have applied to the neck at some time. And then on the hands, of course, there's blood on the hands, but there's also some bruising, and it's better seen on the photographs actually, where her arms are down to her sides.
I'll show you defendants exhibit B.
Okay. So what we have is we have some bruising here, some bruising there, and there are some other pictures where her hands are receiving the knuckle side, and you can see some discolorations there. Now, the probative value of these are more difficult because I'm not quite sure of the age of these. I can't say that this occurred immediately before the legal event or not. But nevertheless, what you have is you have some bruising on the arms, you have some bruises on the knuckles, and you have a discoloration in the front of the neck. And that only came up primarily because of the defense theory that there was some physical interaction preceding the lethal attack.
Okay, I'm gonna go to the demonstration now that,
You said that there were other photographs that you looked at that showed the neck better, was there another photograph?
you can try to pull them up,
There's
Judge.
about a half dozen
There are
photographs.
quite a bit. I will see if I can look at some additional ones.
All right, go ahead.
Going to the demonstration, Judge, this is a digital evidence, so I have a USB to give to the clerk. Would you like to, what is on? There are 3 videos on there. The first one will be the video where he was at the demonstration. The second one is Mr. Bradman doing the night ride, and the third one is the,
Oh yeah, those wouldn't make that mark he was talking about.
3 different USBs. George, how would you like to do that? Because it's all 3 videos on 1 USB.
If they give me 3 separate USBs, I would do that.
okay, can I replace this one?
So let's have, let's just go ahead and name which video is going to be each item of evidence, and then we'll replace them with 3 separate USBs.
The first one would be, and I'm going to see one.
Hang on. I didn't do that right. Yeah, an OnlyFans model. That's exactly who would buy these 3 that I'm fixing to show you, if I can. $200 for 3 knives. Those 3 knives, $200. But see, this is what I was trying to explain to y'all. In my poor grasp of English. It is my first language. It's my only, well, it's not my only language. I can speak Tarzan Spanish. But see, you wouldn't have a mark. There's no hilt. There's no like handle where the handle starts. Well, I'm sure for that price, it better be great quality. But there wouldn't be a mark. But like I said, the bone, because that artery's under the bone. So it probably, the bone slowed it down and wouldn't have gone all the way in. But yeah. Oh my God. I would be afraid. I mean, I don't think I could hold. I couldn't, like, I don't, well, because of the fibromyalgia, my muscles are weaker than like the average person. So I don't think I could hold those with enough grip to actually use them, to have the strength to cut through anything with them. I have enough trouble with knives that have a real handle on them. Okay, let me find it again.
Will be the video demonstration with Dr. Ritchie.
That's going to be defense A3 will become defense C.
The next one will be a knife throwing demonstration video by Mr. Bratton.
A4 will become defense exhibit D.
And then the next one will be a body cam statement.
A5 will become defense E.
Thank you. I'm actually going to show you defense D first, because defense D is the actual demonstration. Can you walk through for the court an understanding, you know, where did it take place, how was it?
Sure. I'd rather stand up and.
Whatever you need to do, I just have to make sure that she can see. And so as long as she can see, just like that.
We all good? Okay, so Your Honor, arrangements were made for me to fly to Columbia, South Carolina, where the studio would be setting up this production. The setup actually went on for a couple of days, and I arrived on the second day. The studio arrangement was indoors, air conditioned, and had video set up from a number of different angles. One was capable of slow motion and all sorts of technical things. The video was shot while I was there. You know, they began to work on a project which consisted of taking the side of pork out and hanging the side of pork or hanging the side of pork on the front of the backstop board. And there had already been a layout of the physical distances between that board, that target, in which Mr. Bratton would be standing to throw the knife set. A set of 6 identical knives, presumptively identical to the weapon involved in this particular case, were available to Mr. Bratton. And then he began to do what he does, and that is throw knives. And I observed him throwing the knives, and then the penetrations, that is, the areas where the knives impaled, I then inserted a glove finger to make sure that the tissue, in fact, was a reasonable representation and similar to human tissue that would have been affected in this particular case.
Do you know how many times Mr. Bratton threw the knife that day?
I don't know. I don't remember.
And can you say whether he hit the target every single time?
No, we did not.
And we already, I believe that you already agreed that the distance that was created for Mr. Brown to throw, it was your understanding that was made by the defense, right?
Correct.
Ask that question again.
The distance used for throwing was decided by the defense.
That's correct.
In your medical opinion, does the pressure used to cause this type of injury, does it depend on the strength of the person?
In this particular case, this particular knife, in this particular location, very little strength is needed either for a direct thrusting of the knife with the hand, that would be 6 to 12 pounds. And throwing the weapon just simply adds it's a little bit different than pressure, but it's a ballistic event. And you don't need a lot of strength, and you don't need a heavy knife, and you don't need a specifically designed knife providing this point. It doesn't have to hit. It doesn't have to hit point on directly perpendicularly. It can strike point on, you know, below or above the horizontal plane. It's still penetrate.
Now, would you agree with me that Mr. Branson's body size is not similar to Ms. Clenney's body size?
Right. He was, I think he was 5'10" in height, and he was overweight, and I think Ms. Clenney was proper to be 5'8" and 150 pounds at the time of the incident.
Does that change your opinion, the fact of how the pressure and how it goes in with the knife? Does it change your opinion based on the fact that you watched a demonstration with an individual that is not similar body size, weight as Ms. Clenney?
No, I mean, it's qualitatively the same event. It's just a matter of different body mechanics, and Ms. Branton could better address that. I'm not an expert in how people throw knives who are novices, And so he could talk about that.
Judge, at this time, I would ask to publish Defendant's Exhibit D, so we can have Mr. Maricini confirm that was what he observed on that day.
I don't understand why the knife thrower himself can't testify, why they're doing it through this guy. Because this guy has medical. It doesn't make sense to me.
Now, we're going to see there's no sound here. Do you know if there was sound recorded or not?
We did not get a sound recording.
Can you describe to the court, I mean, obviously we can see what's going on, but from your observation as an expert medical examiner, what, if anything, does this demonstration show you?
Well, he threw 6 knives, and he essentially had 3 of them stick, and the 4th one came in and hit one of the 3rd one, knocking the 3rd one out, but probably that would have been an impalement. Then there was a clean miss, number 5. Number 6, the impact was just barely grazed the side of the carcass. It was not representative. So what we did was, where this, you can stop it, please. Go back 1 inch.
Okay.
But what we did was, in the knife at the point of impalement, where the skin touched the edge of the knife, indelible marker was used to mark the side of the knife. And then after, as you see here, and then after that happened, the knife was removed and simply put in front of a tape measure ruler to measure the inches of penetration. And so that's what's being happened here. This is, you can see that this particular penetration was in excess, close to 5 inches.
You know what pigs don't have, y'all? Pigs don't have collarbones.
What was, in this case, Mr. Obumselli, the depth of the knife wound? What was that?
It was about 3 1/4 inch, something in that order.
I'm going to show you Defendant's Exhibit C.
Well, that's me, obviously. So what I'm doing is inserting my finger in the defects above and penetration to confirm that the resistance of the tissues and their general features was similar enough to represent the useful for analysis of the penetrating wound present on Mr. Obumselli's body.
And you said you did this, what was the result of that, by you putting your finger in there? What did it tell you?
It confirmed that the tissue was a satisfactory representation of the human tissue for purposes of this experimentation.
Oh, I call BS big time. Because there's a bone in front of the artery. Y'all are going to get sick of me saying that by the time this case is over.
What are you doing right here?
All right, so let me just show what I did, and then I'll explain what I'm trying to do here.
This is why I wanted to be a legal nurse consultant, y'all.
You can freeze it for a moment. So what I'm trying to do, what I've done is I've inserted the knife and then turned it, rotated it to see if I could find an accessory mark. Now, why is this important? In this particular case, when you look at the wound as it goes through muscle, fat, fascia, etc., that wound is just an elliptical wound like you expect to see with a knife injury. I can draw that at the whiteboard in a couple of minutes. But the question was, let me come back to it. Let me show you our image and then.
And if you're gonna show us something, can you just reference what you are looking at, please?
Yeah, do you have what I use?
Mr. He's referencing
The picture of the knife.
information from. Nothing, I just wanted you to see what he was referencing.
Okay. Let me get a color version of that. I'm sure.
So what you reviewed are the autopsy photos and specifically the wound that was on Obumselli.
By the way, this is something else that might be useful if you want to look at that later. Okay, hold on a second. I know I got it here. All right, so this is a picture I'd like to
Well,
show.
it's not in evidence, so,
You want me to hand it to you?
yeah.
You can have my copy. And actually, what I'd like to do is two.
Prosecution needs to get some kind of a mock-up on a skeleton
So
and do the same thing
these two,
with like ballistic gel or some equivalent on a skeleton with a collarbone, because a pig carcass is not an equivalent. Where's the Mythbusters when we need them? The perfect case for the Mythbusters.
Judge, without objection, will be moving defendants F and G into evidence.
A6 will become defense F, and A7 will become defense G.
And I'm going to show them to the court first. And then Doctor, if you'd like to, if you could just reference whichever one you're looking at the time, and you can explain your time.
photograph which gives a general location of the entrance wound caused by sharp force.
Exhibit F.
Right. So you can see this is an elliptical wound. The wound is typically bigger than the knife itself. And the reason it's bigger than the knife itself is that, in my opinion, this defect that we have here is not from the knife just coming directly perpendicular, but from a slight angle. And I can show you a larger image of this.
Why is that important, or what does that have to do with your opinion in this case? The slight angle.
Well, Your Honor, that slight difference doesn't mean a whole lot in this case, except that I wanted to explain the size and marks we're talking about. All right,
Now
so
looking at defendants G
defendant's A7.
and G.
Oh, no, G, excuse me, I'm sorry. All right, A7 is a larger picture of this hole. Now this is like 4 centimeters and change in size, and the width of the blade is not nearly that wide. But getting back to the original, why am I doing this to the side of pork with the knife and twisting it? I was trying to figure out this mark right here in the skin that's adjacent to the hole. The hole is like an ellipse. If you look further in, it's a rather narrow.
Hey, love. Happy New Year. Give the baby kisses for me. Oh, I paused it at a bad spot. I am so sorry, y'all.
There seems to be more going on with this one end. And so I was trying to figure out if that was a evidence of a twisting in the blade, either in reference to the state's theory or in reference to what had been proffered, which was that Mr. Obumselli removed the knife himself from his own chest.
Oh,
You
he
know,
removed it.
well, if he did that, well, could he have twisted it, taking it
I
out?
thought she took it out.
Naturally, not naturally, but you might expect some difference in mechanics from a throw knife and a removal and so on. But when I attempted to do this duplication, I didn't see a lot that resembled this. So my bottom line conclusion is that this is an artifact related to attempts to save Mr. Obumselli's life. And you can see basically some suture holes here where the needle went through with suture material. And it's probable that this is just an artifact of the attempts by the surgeons to save his life. But I went through the extra maneuver of...
Can you guys still hear it?
And it really didn't look like that at all. When you went twisting the knife, the cut came off at more of an angle.
Okay, 2 questions. Can you still hear it if I take it down? And is the picture grossing you out? Do I need to take the picture down? I mean, I'm fine with the picture, but I've seen much worse. Oh, no. I paused it to talk, but I took the picture off. Could you still hear it when I just took the picture off and it was just my face? Whoop, that's the wrong one.
Angle here and further up. So this is not from the twisting of the knife blade either, coming out by either parties. So I wanted to dispense with that in case they became an issue at a later date. So that's what I was doing with the side of pork after Mr. Brent had done most of this work.
How did the pig's skin and density compare to the location of the wound in Obumselli?
Well, I would expect that pig skin.
And objection to the speculation, he wasn't there for the autopsy.
Let me just be clear, from your review of the photos and the records by the medical examiner, how would you say that the pig skin and density compared to a human body, first of all?
Well, let's talk about the skin per se. The skin here is processed a little bit to remove the color. What remains, the epidermal remnant of this skin is probably a little bit tougher than human skin at this particular site. Unlike the elbows, the palms of the hands, the forearms, and other areas, this area under the clavicle, the skin doesn't have particularly a lot of resistance or as much structure as elsewhere. So once again, if anything, the pig skin per se, in this particular model would offer more resistance but certainly not less resistance than the skin of a human being at that site, based on my dissections of that area, you know, 4,000 autopsies.
Yeah.
No, you weren't present for the actual autopsy of Mr. Obumselli, right?
Correct.
So you didn't actually get to feel what his skin feels like.
Correct.
But as you said, in your over 4,000 examinations, the skin type differs so greatly.
It doesn't differ that much, and you know, this area is cut through very often because as you may know from an autopsy, there's a wide incision in the front of the body. So we very commonly go through this area to enter the body as part of the basic autopsy procedure. So I have a lot of experience cutting through this area in, you know, thousands of autopsies.
The state, you read the examination, direct examination and cross-examination from the other hearing, the medical examiner, and you heard him, and his opinion is that this could not have been an injury caused by a throwing of the knife. Do you agree with that testimony?
No, an objection, Judge, said that wasn't his opinion. It wasn't concluded, like, his complete opinion.
I mean, I will rely on my own memory of what it is he said. I also have a copy of the transcript, but it's just all I had to do questions about it.
Right, it's my understanding that the medical examiner's statement as reflected in the transcript was his opinion. It was his opinion that a knife thrown by this penetrated and caused the woman in question.
And did you
And I
say?
disagree with that for the reasons we just talked about.
Okay. And you reviewed Ms. Clenney's statement.
Yes.
Is your opinion consistent with Ms. Clenney's statement that the knife, she threw the knife?
Yes.
If I can have a moment, Judge.
Okay, now that I see the wound, it went in at a different point to where I thought they were talking about. Not saying that I've changed my mind, but now I'm not as sure as I was before. I still think it would have been a fluke if she did it throwing it. I'm not as 100% sure as I was before. So now I'm really anxious to see this trial because it looks like it would have gone in underneath. I was thinking over the top. But where the wound is, it looks like it went underneath the collarbone. But at a downward angle. So I'm confused.
So first off, you were hired on this case by the defense team.
Correct.
You explained to the court your hourly fees
Oh my God.
$600 per hour.
and 2 days, including your testimony today. How many hours have you appeared or worked on this case?
Around 15,000 would be the amount. So do the math.
Okay. So now, this experiment that was done, you were brought in and informed of the circumstances. You yourself were not outside of the defense team. That's your only knowledge of what happened in this case.
Well, yeah, I mean, I think the statement that the defendant made at some point in time was sort of an approximation. So she was in a room, and they asked her, how far away were you? And she said, how big is this room? And they said around 10 feet or something.
That wasn't the question. He's not asking what you know.
What was drawn for that was an initial 10-foot measurement. So all of that was a profit.
Well, you've seen the video that was just shown to the court. It's your opinion that that is a 10-foot distance?
No, there's a 10-foot range set up, but Mr. Brandt has moved in closer for the actual total.
Can you explain to the court why is it that Mr. Brandt threw from 5 feet instead of the 10-foot distance of the room that the defendant stated in her statement was roughly the distance that the victim was from her?
It's my understanding from a proper defense that they revisited the scene with the defendant defendant or talk to the defendant at some point and establish where exactly she was standing and where exactly Mr. Obumselli was when the event occurred. And they recalibrated to an opinion that it was about 6 feet.
So you were not there for those conversations,
Correct.
but it's your testimony today that the defense disregarded the defendant's own statement to police and created a different distance based on subsequent meetings with her.
Right, if you want to go back to the video, we'll go over that. But at the end of the day, an adjustment was made based on the defense doing an assessment at the scene.
She changed her story,
What
y'all.
the actual distance was. And using that assessment, they then instructed Mr. Branton as to what to do.
Are you aware of who was there for that subsequent meeting?
No.
And in regards to the style, and actually, so we're discussing the conversation, the actual statement of the defendant. So not only has the defense disregarded the distance that she says, can we talk about the style in which we see Mr. Branton throwing these knives?
Sure.
And the video speaks for itself, but, and correct me if I'm wrong, he's stepping forward into it and directly throwing it almost, as a pitching, not necessarily hard.
Right, he's using a different style. And he's using forearm extension at a closer distance. And we had some discussions of what happens at 10 feet. He was doing something a little different at 6 feet.
And why is it that we are seeing him change the style of throw from what the defendant said she threw this knife like in her statement?
Well, I don't know that she gave a lot of particulars exactly how she threw the knife.
Well, you have good knowledge as to the distance that she says. You should also then remember that she says she flung the knife. Right? You remember that?
Well, she said she flung the knife, but to me that doesn't, it's like saying I flung the baseball. I mean,
Well, you
yeah,
also.
I don't know, I don't have a clear idea about how much follow through or extension used our arm. And I think Branton discussed that a little bit in his depot.
Well, when you end up receiving this statement by the defendant, was it the video recorded statement or was it audio?
I can't remember.
Well, do you remember being able to observe the style in which the defendant showed the detectives how she flung this knife?
I can't remember.
You are in agreement, though, that Mr. Brennan has changed the style in which the defendant has shown the detectives she threw this knife.
I would rely upon the view of her statement, the image, the video. I can't remember what the video showed.
He has cross-examination, y'all.
Compare that video and what Mr. Branton has done. I don't know what else to say.
Well, you said also you had a chance to review Mr. Brennan's deposition.
I did.
All right, and you are quite aware that Mr. Brennan says, he can't confirm whether Courtney would be able to throw this knife, if the defense attorney would be able to throw this knife, but he would say that he could at least get the knife to stick.
Sure, that's what he said.
Him being a knife throwing expert.
Yeah, sure.
And you have no knowledge as to the defendant being a knife throwing expert.
Correct.
You'd also agree that, and it's very clear from the video, the differences in body shapes and sizes for Mr. Brennan and the defendant.
Yes.
He's got multiple inches on her.
He's stronger than her.
He's several inches taller, and he's also probably twice as heavy as she is. So.
And logically speaking, someone who can generate that, or has that much weight to them, would be able to generate a much larger amount of force stepping forward.
Yes.
So the fact that we're looking at the larger than the defendant, taller than the defendant, Mr. Brand, throwing a knife from a different distance than what the defendant says, this experiment is completely different than what the defendant said and the circumstances she faced at the time in which Mr. Obumselli was killed.
I wouldn't say it's completely different. There are some differences. I'd rather than me trying to go from memory, I think the court will draw out those differences in time.
Well, that's why in a hearing I can ask you about your memory. So go ahead, tell me, what are these specific instances that are the same?
Well, the weapon is the same.
Oh, let's talk about the weapon. So the weapon itself, did you go and inspect the weapon?
I didn't expect the original.
Why not?
The weapon was identical to the exemplars, number one. Number two, I would not be at liberty to throw the original weapon. Number three, there was sufficient photography of the original weapon to show that the tip was not dented and that the weapon did not seem to have significant wear.
But you would not be able to determine the actual wear, the actual sharpness of this weapon unless you analyze it yourself. Is that not correct?
It's true.
Right, so you guys for this experiment purchased knives that are of the same type.
That's a good point. Brand new
But you did
knives.
not create the circumstances in which this knife that was impounded, that would have been available for you to inspect, to make that comparison.
I worked at the proffer that there was no substantive differences between the test knives and the actual knife in the event.
You talked about the resistance of the human body, but again, you're not there for the autopsy of Mr. Obumselli, right?
Correct.
You don't know the condition of his skin, the muscle density of his body. You could not recreate that in this pig without actually being a part of that autopsy, right? You could not guarantee that to this court.
I can guarantee that it's reasonable. I can't guarantee it's identical.
So again, you are changing the circumstances that were faced that day.
Well, we don't do experimentation on human tissue, so we have to do the best we can with mammalian tissue. But yes, it wasn't, 100% identical to that of Mr. Obumselli.
And now, have you ever seen or observed the defendant throw anything?
No.
Do you know whether or not she could, actually, not do you know, you don't know whether she could generate enough force as Mr. Brand throwing that knife at that pig carcass?
Well, I don't know about the word no. I think it's likely she can, and the reason is, the penetrations that Mr. Brandt got were almost 5 inches, and we only really need 3 1/4 to duplicate what was seen in this particular case.
So again, though, you're saying it's likely. You will have to speculate because you don't know how she throws, you don't know how hard she can throw, and again, you've changed the circumstances and style in which she is thrown in your experiment.
I haven't changed anything, but I observed what was done by Mr. Brandt.
And this observation, this experiment was set up by the defense team.
Correct.
You are also quite aware that multiple attempts, the court has only seen one of these attempts at throwing multiple knives at the carcass, right?
I don't know what you've seen. I know there were a number of hours of video talking.
So then you would be aware, you were there for all of it that
Yes,
day.
I was.
And so you were aware that roughly only 50% of the knives, even Mr. Brand, he was only able to get roughly 50% of the knives to stick on that carcass.
Well, in the last video we saw, it was probably close to 4 out of 6. One knife knocked the other knife out. When 2 knives coincide at the same target, they generally interfere with each other, and then you wind out with neither of them sticking. So, but the answer is, let's go 4 out of 6 in that particular run. I'll go with 3 out of 6, that's fine. It's not 100%.
Right, so the knife throwing expert can only get 50% of the knives to stick at a closer distance than what the defendant explained in her statement. She was from Mr. Obumselli.
All right, so that's an interesting point. That means that the defendant had no reasonable expectation of seriously harming Mr. Obumselli.
You mean throwing a knife at somebody isn't expecting to? That her allegation of throwing a knife? I would say throwing any knife would be inherently dangerous, no?
Oh, it is. But lethal, you're telling me, and I would agree with you, that it's not a high probability that she would connect. But nevertheless, if it does connect, then you have an individual like Mr. Obumselli who's legally injured.
And so you would agree that the experiment that you observed is different than the circumstances in which the defendant faced that day?
It could be. I can't affirm 100% that there's total agreement.
You mentioned during autopsies that medical examiners, cut open this general area of the human body, right?
Correct.
What is the type of device that's used to cut open a human body?
Well, you could do different things. I would typically use a scalpel.
And so the amount of force that's needed to cut open, you can't say that that is what Mr. Branton is using in this experiment.
Mr. Branton. Okay, I'm sorry. Could you repeat the question?
Of course. So the amount of force that one would use to have to use a scalpel to cut open someone's chest, right there. You can't say that that amount of force is the same that Mr. Branton uses in the experiment.
All I can say is when I went to cut the skin of this pig sample with that knife, that was almost as easy as a scalpel. So it's a very sharp knife because it's very, very easy.
You mentioned that there are no markings on the defendant's hands for slippage. Again, you don't know the circumstances. You weren't there on the date of the incident to determine slippage. Whether or not the knife actually slipped in her hand at all when she stabbed Mr. Obumselli.
No, what you can say is the converse, that if she was holding a knife and if she was stabbing it the conventional way, that there was no evidence that the knife slipped up the blade engaged the palm or surface of the hand or any other surface of the hand.
Yeah, that happens with multiple. He had one stab wound. That's with multiple stab wounds.
You mentioned for the photograph showing the bruising on the arms, you can't tell at any point in time when those bruises were left or how they were left.
At any point in time, I'm willing to say that the bruising is probably less than a week old. But how recently, I can't say.
And that would be the same for any sort of marking on her neck.
No, not really. I mean, the marking on the neck looks completely different than the bruising in the hands. The bruising on the hands is innocent, multicolored.
And could you show the court exactly, this is state or defense exhibit A, exactly where it is that you're talking about this marking on her neck?
I would just ask if I could use the original photograph here versus a copy because it's not as clear in the printout.
This is your evidence. So you can, I have no issue with you showing it, but I would just I'm trying to have him point to exactly where the court should be looking.
Oh, show it.
Okay, Your Honor. So we're seeing some discoloration. Step down, so have another advance here myself. So, we look here to see if we can see any discoloration, but more importantly, whether we see any reddening of the skin in these areas. So this is inconclusive. I don't mean to affirm to the courts that I can look at this and say, that's it. But nevertheless, we are concerned about these marks, and there are better images from the collection images of Ms. Clenney than this particular photograph for both the hand and the neck stuff. So.
But again, though, you have no clue how, if there are any marks, how they got there, or what.
I was asked in a proffer, could this be from Mr. Obumselli applying force to the neck of Ms. Clenney? If the question was, could it be, the answer is yes.
What is the cameraman's fascination with her handcuffs? Oh, good Lord.
So Judge, the only other thing that I would do is, if Your Honor so wishes, we can introduce, we have the other videos, if Your Honor thinks you need to see them. Otherwise, I have no questions for you. There's multiple attempts, so Your Honor only got to see one of the tests. I guess the number of throws, there's, I believe, 4 other attempts at this purpose, to throw knives. So, if defense is willing to stipulate, okay. So then, we could publish them, Your Honor, or if not, then we could just provide them to the court for Your Honor to review. But
Are they on the same, are they all any the same?
we'd have to mark it. We'd have
Okay, so you can publish it and then, we'll have it marked as a lead as well. You could just put the additional 4 videos as part of the state's evidence, and they'll apply the different variety of those videos. Can we go ahead and publish?
Yeah, no objection, Judge. I was just saying it's gonna be, they're very lengthy if we go start to finish. I don't know if they can cut.
How long are they each?
They're roughly 3 minutes, I believe.
We have no objection.
Show me a couple of
Minutes is
they're long,
lengthy?
and I'll go ahead and get them back.
Hey, Robbie, Happy New Year. Dang, they even got an overhead camera. Still say they need an anatomically correct equivalent. I'm feeling much better today, Robbie. Thank you. They need to get a skeleton and put ballistic gel over it with some type of an artery system. Have somebody her size. And she wasn't standing there aiming. They were fighting.
And while we're setting up this third one, just very briefly,
Yep.
Mr. Maricini, Dr. Maricini, I apologize. If we could pause that really quickly. In the same way, for purposes of trying to stick it into a target.
Well, when I threw it from 10 feet, I felt it different.
So the question I have then in that regard, in this instance, do you have any knowledge as to this is in fact the way that it's alleged that the defendant held the knife when she apparently threw it?
I don't know. By the way, just to clarify, even though the left foot is extended forward to here, his belly, the front of this gentleman's belly never really goes past 6 feet. And the center of mass, even though he leans maybe a few inches, doesn't really step through the throat. So it's a forward leaning of the torso, really only a matter of a few inches at most. And the center of mass is basically moving from here to there as he executes the throw. So it's not like stepping into a 1-2 throw, it's still a relatively static throw.
So Dr. Mancini, you picked out the pig carcass that was used in this, right?
Yes.
Did you, when you're making these experiments, doing these experiments, are you replacing the pig every time?
No.
So in essence, if you're hitting a spot that already has a knife mark, it is easier to penetrate.
Yes.
Ask him if a pig has collarbones. He's asking good questions. There's only one question that was a stupid question. I don't remember what it was now, but he asked it a minute ago, and I was like, that was not a good question. Oh, it was the scalpel. It was if the scalpel and the knife was the same pressure. I was like, that was not a good question. But all the other questions have been really good. Now you need to ask about the bone, though, because there's a bone in the way. This is why attorneys need legal nurse consultants. This is why I wanted to do. I will kick myself forever for not going back to school to become a legal nurse consultant. And now I don't have a license anymore, so I can't do it now.
Because I don't have any other questions for the witness.
And 6-1A will become 6-1.
Dr. Maricini, prosecutor asked you about different circumstances that were reviewed in this case, other than what really Ms. Clenney said. Do you remember him going over several of those circumstances? Okay, so the first one he asked you about was the way the knife was thrown, and you mentioned that Courtney said the word flung. Do you remember him asking you about those questions?
Yes.
After reviewing the testimony, do you know whether law enforcement or the detectives asked her any follow-up questions to be more specific about what that meant?
It's not my recollection that specific questions were asked.
Now, they asked you about the 10 feet, that was something Ms. Clenney said in her statement, right? Do you recall that the last thing she tells them is they should look at the room,
Yes.
meaning the apartment?
Yes.
Objection to speculation.
I don't know.
No, it's not that for what the defendant meant in her statement.
Oh, I thought she was asking what was actually said in her statement, and do you recall that being said?
No, the last statement, Judge, was a speculation as to what she meant. Whether it be the apartment or
I think you
the
said
house.
they should have. That's her. just going to show you defendant's exhibit H, excuse me. Can you just take a look and tell me if this is something that you have reviewed? Both pages.
Yes, I reviewed it.
Let me give a copy to the court.
Is there evidence or not?
He's holding the one that's actually in evidence, that's your copy, Jen. Looking at defendant's H, this is the diagram from Courtney Clenney's apartment,
Yes,
and, this is from crime scene, right?
presumably, yes.
You said that in the beginning of your testimony, you did review documents given to you from crime scene.
Yes.
And can you tell us, looking at number 15, going to the second page, what number 15 actually is? What was located there by crime scene?
I have to look at the alleged counsel, I wouldn't want to speak from, let's see. The global knife was located at 15.
Okay. And looking at the diagram, you listened to her testimony. In her testimony, do you recall where she said that she was by the island and then she threw the knife at Obumselli?
I would, yes,
And looking at the distance between behind the island and 15, would you say that's less than 10 feet?
I'm sorry for where you
If you can tell, if you can't, that's okay. If you're able to see from the diagram that it looks that it is less than 10 feet.
Well, the
Based on the-
island looks less than 10 feet.
Let me ask you this. One of the things she testified to was that Obumselli started aggressively coming towards her, and that's when she threw the knife. If somebody starts moving,
Judge, so first off, this is outside the scope of my cross. Also, it's calling for a speculation.
Judge, I don't think it's beyond the scope because he asked questions about her testimony, various questions about the testimony, and the circumstances that are different, so.
Just hear what the full question is.
The question would be that if somebody is moving, how the wound or how the knife, if it was thrown, how it would be consistent with the wound.
Okay, I'll allow it.
The wound that you observed in this case, Dr. Maricini, how was the knife? Was it at an angle? Was it straight in? Can you tell the court what it looked like?
I do apologize. Are we talking about the carcass or are we talking about autopsy?
No, the autopsy of Mr. Obumselli.
Okay, so the knife wound goes inward, mostly front to back, but slightly from the deceased right to the deceased left.
Can you describe whether, does that mean it was at an angle or not an angle?
Well, it is a slight angle, in my opinion. The ME didn't seem to think so. It's not that much. And it doesn't change anything by movement, so, as far as I can tell.
And if somebody were, if Obumselli were walking aggressively towards her, would you say that that wound is consistent with somebody doing that?
Objection, judge, speculation.
I'm asking you to, based on her testimony, and you're an expert, so you can give your opinion.
A little bit confused by it, but go ahead.
I mean, it's consistent with that, but it's consistent with many other events.
Now, you were asked whether if anybody else could do this other than Brett, who's a knife throwing expert. Were you present when I threw the knife during the demonstration and it stuck in the carcass?
Oh, good Lord.
Yes.
And I was able to throw this knife and make it stick?
Yes.
You don't know me to be a knife throwing expert, do you, sir?
I don't know you that well, Counsel.
And
I'm
your,
just wondering whether they're gonna be amending a witness list and maybe testifying as to how much force you might have put into that.
your fees in this case, are they in line with an expert who has your same experience?
As far as I know, Counsel.
Have a moment, Judge. I have nothing further, Judge. Yes.
Right, can this be excused? Can you step down? One question really you need to ask the recross?
Judge, I would ask probably two.
Go ahead.
In regards to the last questions about defense counsel potentially throwing a knife, was that ever recorded? Do you know?
Well, now unless the video is still running.
Okay. And the circumstances to which she threw this knife, were you made aware of any of them at the time that she threw this knife?
I can't recollect.
And lastly, the exhibit, which I believe is H, the CSI diagram, the item that is marked as item 15, you would have no knowledge as to how 15 got there.
No.
And you would have no knowledge as to whether Mr. Obumselli was standing right in that specific spot when he was struck by the knife, as alleged by the defendant.
No, I mean, the knife is more or less at the beginning of the blood trail where it's found.
And in regards to her statement about where she's standing, you would have no idea of where exactly around this island to be able to place her on a specific spot on this diagram.
I have no opinion.
I have no further questions.
I have had the request for a quick break, so if the witness is allowed to step down, we'll take a 5-minute quick break. I think.
Okay, that was all of that one. I was wrong about a couple things. I thought she pulled the knife out. She didn't pull it out. He pulled it out himself. And I thought that it went in above the collarbone, like up here, but it didn't. It went in underneath it, like down in here. And he was like, I disagree with the medical examiner. He didn't think it went in at an angle, but he said it went at a slightly downward angle because somebody asked the medical examiner if there was a medical word for slightly. I remember that question because it was so stupid. So he did say there was a slight downward angle. So if you're coming in this way, it would need to be up, not down. So now I'm confused. Because, see, I was thinking that maybe somehow she got above him, like he was, that they were like fighting or whatever. And somehow, even though she's shorter, because of the way they were fighting, she was able to get above him with the knife and go above it. But now that I've seen the wound itself and it's below it, I still don't think she could make it throwing it. Because it's still got that bone in the way. Either way, You got to go under the bone, whether you're going underneath or going in top. That's why I say they need to have like a skeleton mock-up with ballistics gel, because that's what they use for bullet penetration. I don't know if that's the same equivalent for a knife penetration, though. Some kind of thing, because that pig ain't, I was going to say ain't cutting it, pun not intended, but because they need something with a bone there. They're like completely not even, it's like they don't even care that there was a bone right there in the way. Okay, so this, oh, you guys are giving me happy faces. This next one, remember the one that I had planned for like right before Christmas? That I guess I got the date wrong. I think this is it. So we're going to watch this one next. I've not seen any part of this one at all. So I think it's a Zoom. It looks like it's a Zoom. It's about an hour long, and the sound is good. The little, like, I don't know, 30 seconds or so of it that I watched.
Versus Courtney Clenney. If everybody wants to announce their presences.
And Kathleen Hogue for the state of Florida.
Sabrina Puglisi, Frank Prieto, and Diane Krupnitz for the defense.
Okay. And then good afternoon. And then I have the motion to intervene from the Miami Herald. Okay. All right. So we had before us what defense had titled as the unopposed motion to determine the confidentiality of the court records, and the state's memo of on regards to that motion. So we're here right now for that. It does relate to the motion to depose Mr. Khalil Quinnen. But right now the motion for intervention is what I think that we need to address before we go forward with that motion to depose. I hear from everybody, including Miami Herald, about that request. I did read through everybody's, well, obviously the original motions, the Miami Herald's motion to intervene, and then the responses to the Miami Herald's motions to intervene, which I think were filed by both parties this week. So let me hear from the state and defense, both about the initial motion without referencing anything that's not already on the court record about what you're asking to be confidential. I think at the last setting, we almost went into some of those facts. We're not going to do that today. And then I'll hear from all of you I'll hear from the Herald about the motion to intervene, and then the state and defense about their responses to that.
Do you want me to start, Judge, since it's my motion?
Oh, yes, I'm sorry. It is your.
No, that's all right.
Yep.
So Judge, I don't know if you need me to, it's laid out in the pleadings, Florida Rule Judicial Administration 2.420, kind of the process on how that works as far as subsection F in criminal cases, which takes you to a few other subsections, but really it is C9A1, little I, Roman numeral I, that says that records are exempt if it prevents a serious and imminent threat of fair, impartial, and orderly administration. So that's kind of where we start in the rule, and then we move on. You received the document in question, and you know, I think the first thing to say is that document was drafted specifically for litigation purposes. I think that's clear. I also think, I know one of the arguments the prosecutor made is nothing within the document has not already been publicly stated by either of both defense counsel, had not already been made public through discovery, or will not inevitably become public. What is in court, because the defense in a case does not need to be laid out and until and unless the defense is ready to do that. Could be motions in limine that the court puts in an order as far as when that's due. It could be, for example, just generally speaking, if a defendant were going to testify at a trial, the court doesn't get to know that. The defense doesn't have to say anything. The prosecution doesn't get to know that unless the defense announces it, or right before it's that portion of the trial, the judge asks that of the defendant. So I think we can generally speak about the document without going into the specifics of it. Just like anything, it's obvious any defense lawyer is going to do investigation and do research, legal research, and try to find witnesses. Those are generalities, which we can talk about without getting into the actual specifics about what that is in the document. And I think that is what the rule requires for the judicial rule of administration. It says you must be able to specify and identify it, and with specificity, but without going into the reason why it's privileged. So I guess the real question here is this document privileged? It's attorney, client, and work product. We believe it's both. And the standard is different with respect to both. And so I think the first thing the court needs to do is, one, determine if the document, is attorney-client and or work product privilege. Two, if the court does believe it is one of either of those, whether it was waived when the defense disclosed it to a third party that was not Ms. Courtney Clenney. And three, even if the court believes it is one, not privileged, or two, yes, privileged, but was waived, should that still be kept confidential and sealed? And I think this is the only part, and I'm not going to speak for Mr. Ponce, but I think that's where we kind of differ, which is, even if the court doesn't believe this is a privileged document or believes we waived it, it still should be kept confidential because it's information that should not be disclosed to the public. So that's kind of where we're at. And I'm happy to go into each of those. I did brief them, but I can speak briefly as to each of the privileges first and why we didn't waive it.
Give me your bullet points on the attorney-client privilege, and then we'll go into work product. Yes.
Okay. So with respect to attorney-client, if you look at 9502C1 and 2, specifically, a communication is confidential if it is not intended for third parties except one, those to whom disclosure is in furtherance of the rendition of legal services, and two, those reasonably necessary for the transmission of the communication. So the question here is, what is in furtherance of the rendition of legal services? We know that the Clenneys, Mr. and Mrs. Clenney, the parents, are paying the legal fees. That came out in the Arthur hearing. Mr. Clenney testified and he talked about it. So the fact is, and this really applies to any case where family members are paying for the fees of their loved one, defense attorneys do speak to them because they need to discuss. Can you imagine what the ramifications would be if I just went to a client and I said, for example, give me $50,000, and I'm just throwing a crazy number out. Give me $50,000. I'm not going to tell you what I'm going to do. I can't tell you anything about the case. I can't tell you any experts, any investigation, any motion. I'm not going to do anything. That's just not practical. And that's why the court specifically in this rule, actually, that's why it specifically allows for attorneys to be able to discuss if it's in the furtherance of rendering the legal services. And if you look to the case that we cited, Gerheiser versus Stevens, that's Gerheiser versus Stevens, Stephen's. That's a 4th district case from 1998. And there's really not a lot of cases on this, Judge. So really this 4th district case, it was a mother who communicated with the lawyer about hiring or retaining them for her son. The question was whether that communication was privileged. And the court said that, yes, it is privileged because it is in furtherance of rendering legal services. The state cited State versus Black, where it was not considered privilege. And that was a jail phone call between a defendant whose sister made a three-way call to the attorney. And what the court said is, no, this is not like the case of Gerheiser. This is different because one, it says the call is going to be recorded as you're making the call, so that should have been known. And two, in that case, the attorney didn't explain why, that person's needed to be on the call, so it can be distinguished. As far as, and just to be clear, Judge, we were communicating what needs to be done in the case because they need to understand in order to be able to be prepared for the costs that will be involved and to justify the fees that were being charged. So I think this clearly falls within a communication that would be under attorney-client. Now, with respect to work product is actually even, it's even broader. And the court knows about this because in the last hearing we had, you even in the order, you distinguished between opinion and fact work product. The case of State versus Rabin is very good at kind of laying that out. And actually the state cited a case that it doesn't really apply. It was in the corporate context for attorney-client privilege, but it gives a great analysis of work product privilege. And that is Burrow versus Forjas Taurus, Burrow, Forjas is Forjas, Taurus, Taurus. It's a Southern District of Florida case from 2018. I have a copy for the court if you would like. And really, if you go to page 2, Judge Torres does a really great job at setting forth an analysis on work product. He talks about the difference between opinion work product and fact work product. And what he says on page 2 in the first paragraph dealing with the work product doctrine, he says, and this is on 1227 page, because the work product privilege looks to the vitality of the adversary system rather than simply seeking to preserve confidentiality, it is not automatically waived by the disclosure to a third party. It requires the party asserting protection under the work product doctrine to demonstrate that the drafting entity anticipated litigation at the time of the documents were drafted. I mean, clearly this is the roadmap, what we're going to do to prepare for trial. So I don't think there's any question it was drafted in anticipation of litigation. And because this is about what it is, the logic behind it, the rationale of work product is that your adversary doesn't see your mental impressions. And that's what opinion work product is. It's the mental impressions of the attorney. Clearly, these are the mental impressions of myself and my team. And so it was the question, what was it disclosed in a way that your adversary knows? And the question then would become is, okay, I sent this email to the Clenneys. Would I have known that Mr. Quinnen or any of the prosecutors in the case would have been able to get access to the case? I would have to assume that and have knowledge or evidence that they got an iCloud warrant for them. I couldn't know that in the case. The parents are not part of the facts in this charge, and there would be no reason for me to know that. And let's assume that even I was afraid that somebody could look at it. This is why I titled it privileged. I titled the document checklist of things to do - privileged. And I agree with Mr. Quinnen, just calling something privileged does not necessarily make it so, but this clearly is a privileged document when it's my mental impressions. It's work product, I claim it as work product, and I wrote that it was privileged. So the question becomes then about waiver. And just to go back in that case, on page 4, it says opinion work product enjoys a nearly absolute immunity. it is much more stringent than attorney-client privilege, which I still believe belongs here, but it is very hard to waive opinion, work, product privilege. And so then we have to ask ourselves, did that happen in this case? And in the work product aspect of it, Judge, no, I couldn't have protected that document from being disclosed to people other than who was on that email. And the prosecutor stating that we have disclosed some of what's on it or will inevitably be disclosed, it doesn't matter. If a document is privileged, it's privileged from when it was and forever privileged. And so whether it's a roadmap of my case, whether I've already filed a defense witness list with some of the witnesses, whether I filed some motions, I can tell you that at least 9 points in there have not been disclosed to this court, to the media, to the prosecution, to the public. And whether the defense inevitably decides to put that out for trial, I don't even know yet because we haven't even set a trial date. We're still preparing, we're still investigating. There's a lot that goes into it. So I don't even know at this point, but there clearly could not have been any kind of waiver. Let me just see if there's anything else with respect to the waiver, Judge. And I don't know if you have any specific questions about what I've said so far.
I don't.
And I would probably wait to go into the third point, which is even absent those things, unless you want me to, but
Well,
even,
we can wait and see whether or not I agree with the Herald
Right.
that it's.
because I don't think
going
we
to
get,
decide one
Okay.
or decide the other.
I don't think we get to 3. So, okay.
All right, so let me hear from you, Mr. Quinnen, about those points about the privilege first, and then we'll get to the sealing and the confidentiality.
Yes, Judge. I think I would like to begin with Ms. Puglisi's argument that even if it might have been waived in some respect, the document, because it's quote opinion work product, maintains its privileged nature, even if she went on TV and literally said the 20 items on that. And I think that's incorrect. Just as a premise, if we proceed to trial, Ms. Clenney is convicted and she attacks her representation as ineffective, that privilege is waived. We get a copy of the file, we review a copy of the file, as common within a Rule 3 litigation. I think it's actually explicit in the rule and the doctrine about the waivers of privilege that come with that. So that's not correct. We have to read all of these rules together with one another. And so, as Ms. Puglisi correctly cited into 9502, it has to be in furtherance of the representation. So was this email communicated to the parents first as their other clients as witnesses? Yes or no? I think it's unequivocal no. That wasn't, this is what we're doing to prepare you as witnesses. It's, this is what we're doing on Courtney's case. So it was unequivocally uninvolved to Kim and Deborah Clenney's representation by Frank and Sabrina, or excuse me, Ms. Puglisi, Mr. Prieto. My brain just went to your first name. So it's unequivocally uninvolved with that representation. So it's regarding Ms. Clenney's representation. What within that email really discussed, we need, so for example, I'm gonna use Ms. Puglisi's example of money. We need $50,000 to do X. Okay, was that in that email? It was not. Was it, we need you to sign an authorization of school records from Ms. Clenney so that we can build mitigation? Again, hypothetical situation. That's not what was there. That was, we want you to know what we are doing. Email. And that is a voluntary, that is a textbook voluntary disclosure to a third party, period, bar none. There was no request for work. There was no request for assistance. And the Gerheiser case that we cited to, that I appreciate Ms. Puglisi mentioning, And in the original privilege litigation, we also cited to a case called Witt versus Witt, and I can get that cite for that for the court, where there are circumstances where family members can be agents. So in Gerheiser, that was a juvenile who was in custody and could not retain his own counsel. So his mother went to retain counsel. And what was privileged in that discussion was the discussions with the lawyer about the son's case, period, in terms of retaining that lawyer. That's not what we have here. Again, Mr. Prieto and Ms. Puglisi, as we argued in that proceeding, were already retained by Ms. Clenney. They had every means of going to go see her at the jail and talk to her at the jail and explain what they need and why they need it. And as it pertains to her parents, if there's any kind of bill, for example, Ms. Clenney has frequent calls with her parents. She could say, Dad, I spoke with my lawyers and they need the $50,000 for the thing that they're doing. That's perfectly fine. That's perfectly protected. But the problem here is that that's not what existed in this email. That's not what occurred. Besides that, I don't entirely agree that it's opinion work product. At the end of the day, it's just a fact work product of, you know, we have to do X, we have to do Y, we have to do Z. It's not, I think that this is going to be a problem, or I think this witness is not credible, or what would actually impart impressions there. It's essentially call the witness, schedule the witness, get this, and I'm not quoting anything there. These are all hypotheticals because I have to tiptoe around it. It's a to-do list. It's not a we think this, we think that. So respectfully disagree as to whether it's opinion work product. As it pertained to the instant motions, and again, this is a slight shift from the privilege, because again, our position on the privilege has never changed, including as it pertains to the other litigation. And of course, we respect this court's order on that case, though we disagree as we outlined in our pleadings. This is inherently different in various different respects. Again, explicitly voluntary disclosure, but beyond the voluntary disclosure is the remedy. Well, I guess I'm getting into the other argument, so let me back off of that. The state's position as it pertains to the confidentiality was that all of the matters should be confidential because it would necessarily limit our ability to discuss in the response to the deposition motion, the document, because that's a good chunk of their position. So all of the proceedings should be confidential if the state is correct and the court agrees with the state and the court grants our motion or denies the defendant's motion, however that proceeds, then whatever is appropriate to be unsealed would be unsealed. The problem is that candidly, the defendant in their motion to compel and our deadlines in responding to that motion to compel required us to address at least one bullet point in that respect. So it's put us in a position now where, you know, the cat's already out the bag, the bell has been rung. So there's that aspect. And then finally, as Ms. Puglisi mentioned, there's at least 9. I haven't really re-reviewed that document on purpose for this court's reasons and for collateral matters. But if there are 9 things, and I'm assuming it was 20 items on the list, just taking their word for it, 11 of them should not be redacted. So at the end of the day, that's the bottom line law is, as I don't care whether it is or isn't sealed, but that's just the state of the law. So
Judge, with respect to Mr. Quinn doesn't believe that it's work product. So the rules, opinion work product. The rule states the mental impressions, conclusions, opinions, or legal theories of a party's attorney or other representative concerning the litigation. That does not say and in between there. It says or. The mental impressions, those bullet points, it does not say it has to be in a paragraph format, how it needs to be put. Those bullet points show, after evaluation and knowledge in the case, things that need to do. Those are mental impressions moving towards litigation. I mean, I don't think it could be more clear than the fact that this is opinion work product. Now, as far as the attorney-client privilege, yes, this is not a communication that involved our representation of the Clenneys as the parents. This had to do with Courtney Clenney and her representation. And it's just not practical what the state attorney is saying, and I don't think this is what the rule says, which is that, yes, we were retained, but that doesn't mean that costs don't still come up throughout the case, that you're not still discussing with the family about the case. And it says here, he says, Mr. Quinnen said, it's what you want you to know what we are doing. Yes. How is that not disclosure in furtherance of the rendition of legal services? That's exactly right. What he said, it falls exactly under that definition. And so it's just defensive attorneys don't do that. They don't talk to their clients about the fees when she has no access to the money. So you're talking to the people who have access to the money and pay it, and you're talking to them about what you're doing. And this is just very common communication. And as far as even if we've disclosed some, because that's part of our case, we've done it through filing defense witness lists. That doesn't mean that, okay, you can unseal or disclose part of it. I've not read any case that says part of the document can be privileged in part. Now, I have read some cases that they've talked about, okay, if you have 5 documents, maybe one document would be sealed and the others are not, but there's never been something that, okay, part of this document it's a privileged document. It doesn't matter and it should not be disclosed. And again, I won't go into the third point because I think it would matter for the court to determine whether it's privileged or not first, and then whether we waived it. But I think the strongest argument here, I believe work product has not been, or sorry, attorney-client hasn't been waived, but either way, the standard is not the same between the two. It's almost always immune in the opinion work product. So I would just make sure it's clear that the standard is different. And I don't know what Mr. Quinnen needs to say that needs to be on the record that he can't say without like us having to seal the entire proceedings. I feel like we all know, the court and the attorneys here involved know what it's pertaining to.
That's what we're gonna get to next.
Okay.
Okay, so this is the issue of privilege. And what I want to hear next is what it is that, given what you're arguing is privileged, what it is that you're asking, defense is asking to be sealed versus what state is asking me to be sealed. And then we'll hear from Miami Herald about their response.
So I think the rule, Judge, does, if you go through the case, Lewis versus the Miami Herald, I think it does lay it out. And I think the biggest thing at the end is it says it has to be the least restrictive. Because
so for you guys, it's just essentially the one document.
It is. I think that protects it, as long as we are not discussing like the absolute details of what's included. We can talk around it in generalities, but I don't see, and I haven't heard Mr. Quinnen point to anything that makes me feel like we can't do it and just seal that one document.
Right. So Mr. Quinnen, before I get to the Miami Herald, why is it that you believe in counsel for the Herald also suggested that you discuss this with them? Why do you believe that more things need to be sealed if I decide that document needs to be sealed?
Judge, as it is, just as a premise, in our response to the motion to compel the deposition of myself, I had to note at least a single quotation about paragraph 19. Our response, we had to, for lack of a better term, neuter it. So we couldn't go into the dynamics and the aspects. We can only touch about the topics broadly as to privilege, waiver of privilege, why the waiver of privilege was perceived and assumed under those circumstances, and so on and so forth, just kind of broadly. As the court recalls in the litigation on the computer case, the pleadings on these topics were north of 20 pages. And this one obviously was 10 for several reasons, but we could not go into meat and potato issues. Again, as we've been tiptoeing around here and as admitted by Ms. Puglisi, at least 11 of the 20 items have been disclosed already publicly. And again, that buoys the point that voluntary disclosure is waiver, period. So, which by the way, it's their burden to show through evidence, which they also have not done. You know, counsel's assertion is not enough, and admission that this was disclosed to a third party with consent, as we noted in our arguments, you know, that's essentially it, is there was consent to tell the parents the status of the case. Because at the end of the day, as the court noted and the state relied on both internally and externally through advice and research, the parents' representation by Mr. Prieto and Ms. Puglisi was problematic to begin with. That doesn't preclude it. We've gone down the rabbit hole. That's a dead horse that I don't want to beat any further. But the point is that this has nothing to do with the parents' representation, and it only exclusively has to do with Ms. Clenney's representation, and it's completely unnecessary to have been disclosed in those circumstances. Again, the proffered excuse was that, oh, it's to let them know that we need money or we need this. That's not what that communication says. That's just telling them, hey, this is a status.
That again goes to my determination of whether
Yeah.
it's privilege. So I'm asking you why it is that you believe that you can't just reference the document in your pleadings or reference the bullet points in your pleadings without having to.
About that it wasn't privilege and privilege was waived, and I can't address why or how. I can only really say, et cetera. And as it is, again, referencing the court to page 7 of our response on the motion to depose, we narrowed it as explicitly as possible to the pertinent bullet point as to how the document even came up in our search. So, you know, that's just the practical reality of being able to respond on what we already put, and is understanding our arguments around the parameters of that. Again, the first bullet point had to be disclosed. That was part of the problem with this timeline of the briefing, because the bullet point had to be referenced, absolutely could not go without being referenced on paragraph 19 of page 7 of our response. So we were okay with the records being sealed, hence why it was called an oppose, for the purposes of just getting this over with. And then however the court rules is however the court rules, and whatever is appropriate to be protected is protected, and whatever is not, that's perfectly fine. And the pleadings could be redacted and so on. But that I had to file a pleading by last week, Friday, in response, necessarily undercut the defendant's premise of their motion. So they did not have to file their motion to compel the day after they filed the motion to determine confidentiality is what I'm getting at. And by forcing that issue and forcing us to respond within the parameters, it necessarily undercut the premise of their sealing. So,
Any response?
I mean, I don't know what Mr. Quinnen wants to say, so it's hard for me to say that. I mean, I didn't think it was the least restrictive means. I really don't care so much whether it's sealed. I think the Miami Herald has something more to say about that, so I would leave it up to the court. I just felt it needs to be the least restrictive, and if you ask me, that's what it was.
Okay. All right, let me hear from, remind me again your name.
Yeah, Scott Ponce, on behalf of Miami Herald.
All right, Mr. Ponce, if you'll come forward to the microphone, please.
Yep.
Thank you.
Good afternoon, Your Honor. Scott Ponce from Holland and Knight on behalf of the Miami Herald. I think maybe the best place for me to start is to explain why I'm here. I mean, obviously, anytime a motion comes across saying sealing criminal proceedings, my client's antenna goes up. But this one in particular, when we got the motion and read the motion, it seemed to me that there were discrete issues that were kind of being conflated and bouncing off each other. And when I emailed counsel for the parties, from vacation no less, but when I emailed counsel for the parties to try to get an understanding, I got maybe even a little bit more confused. Although the judge I clerked for out of law school said, never say you're confused. But as I read it, what seemed to be my understanding of it was that there's a document, the defense contends it's privileged, the defense would like to make that an exhibit to an amended motion to disqualify. And it seemed like that the issue of whether the document is privileged was going to be briefed in the disqualification papers also. And that seemed to not be the least restrictive means. And that was our concern, was that a motion to disqualify the state attorney's office needs to be done in public. This is a public institution, and the notion that especially problematic because it seemed like it didn't need to be. So our thought was, and I apologize if the papers were presumptuous, I don't think that they were, was that it made sense to determine in the first instance whether the document's privileged. Because if it's not,
I'm fine with the way that you outlined it.
All right. Well, thank you. Makes me feel better then. So the thought being that if the document is not privileged, then I don't know that there's any basis to seal any document to which it's attached. If you find the document is privileged, and again, I'm not attorney for the parties and I'm the stranger here and I know least about this than everyone in this room, but it's not clear to me why the document would need to be attached to anything. I mean, your honors reviewed it, your honor determined it's privileged. Okay, the state saw it. Is there a basis to disqualify him on that basis? I don't, when we talk about least restrictive, I'm not sure why the document have to be attached to something. But again, I think in the first instance, our concern was that there was suggestion in the papers, at least as I understood it, that the issue of whether the document was privileged was going to be briefed as part of the disqualification issue. And that the state's position was that if that were the case, then everything in the disqualification papers had to be sealed. And that felt like too much. So I'm happy to answer questions if you have any. I obviously can't speak to the privilege issues, nor do I want to. But that's kind of why I'm here and why this came up on our radar.
I tend to agree with you as to the way that you've outlined it, which is again why I've asked the state to explain to me why it is that I can't simply rule on this being privileged or unprivileged. And if I do rule that it's privileged, why it means that everything attached to it must also be sealed. And I kind of understand your argument that in order for you to make a full analysis.
Okay. This is the times that I think, why am I streaming legal stuff? So she basically put a to-do list in with her work product. I mean, in with her discovery. Like, she put something in with documents that the state saw and they shouldn't have seen. So now she's trying to disqualify them? Is that what's going on? I'm so confused. So because the Miami Herald thought stuff was going to get sealed because they're the media and they don't want anything sealed, that's why they're there. But this is really between the defense and the state. How do you get the state's attorney disqualified? She just wants a different attorney? You can't get the state's attorney disqualified from a murder case. That specific attorney? You can't get the whole state's attorney's office disqualified. So confused. Can someone please explain what's going on to me?
Believe that you have to reference the exact portions of all the bullet points in the email that was sent. But I'll let you address what it is.
Well, Judge, I mean, again, if the topic has been voluntarily disclosed, then it's been voluntarily disclosed, whether it's
aside from whether or not I say that I do rule that it's privileged.
sure.
Why again?
Okay, so then.
Yeah, but say that I do.
Okay, so then part of the analysis as it pertains to both the deposition and disqualification is what prejudice, if any, right? What prejudice, if any, exists from the inadvertent disclosure of this document, right? And the items contained within that document. Well, what prejudice, if any, exists to the defendant if her lawyer went on TV on July 8th of 2023 and said, we are doing that checklist?
Well, I don't think that that's the analysis that we're talking about for sealing.
No, oh, I'm sorry, I
We're talking
misunderstood.
about sealing right now.
Oh, Judge, again, the parameters is if the court assumes that it's privileged, then I can't discuss those materials openly, right? So if I can't say, you know, they said they were going to hire blank, and they also said that on TV. You see what I'm saying? If the matter is sealed, I can't say they said this on TV. There is no prejudice.
Yes.
So here's where sorry to raise my hand, I was in third grade. Where I get confused a little bit here. Why would that be a discussion in the disqualification context?
Because if there's no prejudice, then there's no basis to disqualify.
Okay, I mean, it's just something I'm trying to understand, trying to be a partner here and work through this, trying to understand why, if there's a determination made that the document's privileged, and there's a determination made that the state saw it, I'm trying to understand why are we still talking about what's in the document or not, and a disqualification issue, if that matters.
Because again, if it's in a privileged document that was assuming it's privileged, because we don't take that position, and the basis of disqualification is they saw our strategy. It's like, but you also told everybody your strategy.
Or why
Then-
should you be disqualified?
Yes.
Okay,
And
that's helpful. I'm just trying to understand.
And that's the problem is I cannot, I mean, again, if the court, listen, Google alerts are a beautiful thing. And so everything on this case that has come up from the defense telegraphing their case ad nauseum, it has come up. So again, half of that, from my original viewing of that, and again, I haven't parsed it recently, quite literally everything on there has been discussed in one respect or the other.
Like you could
So,
reference the bullet points without going into exactly what was in that document if I did rule that it was privileged, because obviously the balancing test here is issues that you guys are talking about regarding the public interest, and there is a right for the public to, you know, view pretty much everything in this criminal case minus what might be privileged. So do you not think that there would be a way to craft your response if I did rule that it was privileged in a way that didn't actually quote anything in that? Because I feel like you could. You're
yeah, Judge, I could theoretically say bullet point number 1 and then X, and bullet point number 2, then X. But then X was already disclosed, outlines what bullet point number 2 is. So for example, I'm just going to use something that is in the public domain. Find Arthur Cupp, right, as the witness that is alleged to have seen everything else, right? Off the top of my head, I don't know if that's there, but you guys check on me. So let's say that's item number 2, find Arthur Cupp. So instead of saying, for example, item number 2 was disclosed to the media on this date at this time by Mr. Prieto when he said, we've located Arthur Cupp. How am I not disclosing item number 2 in making that argument?
Isn't it just you're not using his name?
I mean, I think that you could just say the witness was.
I mean, that's the point is how is it that I don't, in saying,
Well, listen, I don't think that I don't think that you need to worry about that. I think that you can make the argument if they've already disclosed it and if it's in the public domain already, you can reference whatever's in the public domain. And that issue is a defense issue.
yes, and that, I mean, that's we've already articulated
Yeah.
that as much.
So
But that's what I'm saying is at this juncture, we've already gone as close as we can without going and making a deeper analysis on our motion to strike. So at this point, that's why I'm saying is it the defendant's attempt to maintain the records confidential is
that's their issue as to whether or not they have already gone public with this information. But I do think that I could give you the parameters and you could easily, I think, draft a response knowing that I am able to see the document that wouldn't necessarily quote the document. You know, your reference of any public disclosures by the defense, I mean, feel free to reference that in whatever way you want to. It doesn't mean that you're the one putting that, you know, quoting the document. I mean, that's on them.
I also think that if that becomes an issue, we can always go sidebar. Mr. Quinnen can lay forward, you know, to the court, off the record, this is what I'd like to say and I can't say it because of this. And then we can decide that, yes, okay, now there's a basis. We should seal it because you can't make that argument unless it's out.
I tend to agree with you, and I understand what you're saying now. I understand what you're saying about needing to show prejudice for all the elements that are in there, but I think that could be done without referencing the document. Okay. All right, now I lost my place. All right, Mr. Ponce, was there anything else that you wanted to say about that?
Unless you have questions.
All right, do you have anything that you want to say about your response to what Mr. Ponce had said? Because it seemed like you were essentially in agreement with the idea of going with the privilege first and then deciding what needed to be, whether anything needed to be sealed. But you said that there was one thing that you disagreed with, I feel like. No?
No, I don't think so. I
Okay.
think, it was only that if the court doesn't find it's privileged or finds that the defense waived it, I think that Mr. Ponce's argument is then, okay, then it should be disclosed. And our argument would be no, because it still is our mental impressions of the trial and there's no reason for the public to see it. And unlike what Mr. Quinnen is saying, that yes, the timing now is such that it's been disclosed. Some of these things have been disclosed. They're part of the public record, as you said. And we have discussed it in the media, but not all those things have. And that entire document is a privileged document. Whether we have disclosed some of it or all, doesn't mean the whole thing should be disclosed. It's privileged. And so, and I can matter of factly say that not all of those items have been discussed in the media at all. So,
And I don't think that he's disagreeing with that, Mr. Quinnen.
I'm neither agreeing nor disagreeing, Judge. I can't.
You-
Again, I've on purpose recently avoided.
Okay, so yes, you've got your bullet points. All right. Did you want to address anything else that Mr. Ponce had said or that the Miami Herald's concern is, other than what you've already said about why you believe that there needs to be a broader?
No, Judge, we were generally in agreement to maintaining that prophylactically. Our position was just that let's get this over with, and then after the fact, let's just get everything over with, and then after the fact.
Yeah, the idea was to get it over with before the new year. That's not going to happen, but we're at least at this point. Okay, so I agree with the idea of ruling on the privilege first, and then deciding what needs to be. Actually, I mean, I can make the ruling. I can make both at the same time, based on what you guys have said, unless you have any other arguments that need to be made.
Judge, as it pertains to the waiver issue, I mean, I didn't go down the dynamics of that. Again, we have separate parties, and by separate parties I mean there's the state of Florida versus Courtney Clenney. There are witnesses within that case. Those witnesses can have representation at the time.
Sorry, and by both, I'm sorry, I didn't mean to cut you off. By both, I mean I'm perfectly fine with ruling on the issue of privilege and what should be sealed, not that we're arguing the motion toward.
No, it's on the privilege aspect, because again, there were certain aspects of it that go more towards that dynamic. But the essentially the broad stroke rule that the defense is trying to propose, where the parents are always agents of the defendant or have been always agents, is not one that's actually premised within the doctrines of attorney-client privilege or within the jurisprudence or within that rule. And specifically what I'd refer to is several different dynamics. First is the defendant has several jail calls with her parent. Does that mean that completely immaterial, whether it's privileged or not? You know, we should not be, even if it is recorded, I believe all jail calls are recorded even with counsel, but we don't get the ones with counsel. We explicitly are excised. They have to fill out paperwork and so on and so forth. So whether it's recorded or not is completely immaterial. And what's happening here is, for lack of a better term, because they keep using this term Team Courtney in this group chat, that was not evident in the group chat, first of all. But notwithstanding that, is just because you have a support group and everybody wants to know about what's going on and what's being done, it's incumbent on the counsels and their client to keep those lines of demarcation. For example, if Ms. Puglisi met with Ms. Clenney at the jail and said, we're going to do X, and then she picks up the phone and calls her mom and says, my lawyers are doing X, that privilege is waived. Ms. Hogan, I executed another case where there was a similar circumstance where a person their representation was paid by a third party. I'm not going to go into the details because it's a little bit sensitive, but that third party had a complete barriers to the representation. Certainly, if you got a call and say, look, we need X more money because we have to hire an expert, I got to talk to my client about we should excise from there. And I explicitly use the example of when parents go in with a client to an interview and how the parents are supposed to be excluded from that interview with the client if they are to maintain any privilege, because if it gets discovered, we can compel that testimony, which again, to the further privilege aspect is the defense in December of 2022, when this email is being sent, knew A, the defendant was in communication with her mom, both written and oral, that they provided us photographs that Deborah Clenney took from her device on April 6th, 3 days after the homicide, purportedly showing bruising that was, again, purportedly caused by the victim. And so they knew that we had a basis to want Miss Deborah Clenney's phone and the contents of that. And we could have subpoenaed that, assuming she was within the jurisdiction for me to subpoena it. So what is on her phone? That is a textbook voluntary disclosure to third parties. That's what this document is. And again, calling it privilege, naming it privilege does not make it so. That document could have been called privilege and it could have had the scores for the Heat game and the stats. That doesn't make it so. And in this context, even if it was, which we don't necessarily disagree that it was when it was created. We disagree that it was opinion because it's just facts of what we're doing. But once it was put into an email and sent to the third parties, that was waived. And just as a perspective, the two exceptions there are for the purposes of the representation, and I forget the second one, you had it, it's for the purpose of the communication functioning, I believe it's the second one that you mentioned.
Reasonably necessary for the transmission of the communication.
Correct. So it's reasonably necessary. So that would be Outlook or Google or whoever the servicer of that email is. We didn't intrude on Google, et cetera, or any of that stuff. We got it from Miss Deborah Clenney's iCloud. A, not knowing that there was a representation there. And then B, under the circumstances where that email was even open, it said update, not update privilege or privileged communication or any of that aspect. And B, the document did not reference Kim and Deborah Clenney's representation in any way. It was explicitly about Courtney and what they were doing about Courtney's case, which again is textbook, top to bottom, within four corners, voluntary disclosure under 90.507.
Judge, I'm just going to say that I think the state tends to join the two privileges together, and we have to make sure we keep them separate, attorney-client and opinion work product. Opinion, it doesn't have to be your opinions. It says mental impressions. Mental impressions are your thoughts. There's no question. These were my thoughts. And yes, it could have been the scores to the Heat game, but it was not. And it said privileged on it. And the prosecutor should have stopped when he saw a communication from attorneys to anybody and should have said, oh, I see an attachment that says privilege. He didn't stop at that point. He actually forwarded it to law enforcement, thereby making it a public record. So we have to, all his descriptions about it's not a jail call, which of course is recorded, and it doesn't have to be about finances. It doesn't have to say the magic words. This is, we need money from you. It says disclosures and furtherance of the rendition of legal services. These are points that help to justify what is being done in the case to represent their child. So I think it's very clear this is both attorney-client and work product, and that there was no waiver at any time, especially in the work product. It was meant to be kept from the eyes of our adversary.
And you don't believe that that was waived when you disclosed it to the parents?
In
as a third
opinion,
party?
no, because opinion, especially opinion work product, it talks about you can disclose to third parties. The the test, the question is whether you reasonably could have known that it would get to the eyes of your adversary. So by giving, they're two totally different standards. So by us giving this information to the parents of what our opinion is in the case, the question is, could we have known that the prosecutors would have seen this email? And in order to prevent that, that's why you write privilege, so that you know that only the family, the people you're sending it to, are going to see it.
I have a slight disagreement because Ms. Puglisi keeps referencing adversary. So first, again, as witnesses, whether by us or by the defense, they would be subject to subpoena. And we could have taken sworn statements of them and possibly had discussed that, where we asked the question, have you discussed your daughter's case with the lawyers? So it wouldn't be a question about, did you discuss it as a witness and client of theirs? It would be, did you discuss it regarding her representation? And they might have been compelled to answer that. The second part is that the standard is not adversary. It's that the communication was made with the intent to keep it secret. Now, certainly it was meant to keep secret with Kim and Deborah Clenney. The problem is that as third parties to State of Florida versus Courtney Clenney, it's a voluntary disclosure. The very act of attaching it to the email and sending it to them constituted the waiver.
Judge, and I don't totally understand what he's saying with respect to, there's no way they could have been compelled to answer that, but adversary is the state attorney's office in this case. That's who the adversary is to Courtney Clenney. And so clearly it was not meant to do that. And I can find the case, but it does talk about that.
I'll look at it.
Okay.
Yeah, my understanding is adversarial party.
Okay.
Okay. All right, anything further before we stop for the day, and I give me time to read through everything and issue another written order?
No, Your Honor.
All right, so my order will be number one, on the nature of privilege, whether I believe that it is privileged or not privileged, and two, if I believe that either it's privileged or not privileged, whether I believe that anything should be kept confidential, and if I do believe that it's confidential, what should be kept confidential? Okay, so it's going to be three parts. Everybody follow that?
Yes.
Okay. All right, and you're not Marvin, so I don't know how long to ask you for the transcript. What is your name? Alex. Okay, Alex, if I want a transcript, will I be able to get it in 10 days, given the holidays, 10?
Yeah.
They should be there. I have copies. No, I have copies for orders there. If you look, there should, you guys, Ali. No. All right, so let me reset it for 10 days for transcript, and then hopefully we'll get the transcript then, and then I'll give it a reset date with you. And if I get the transcript, I'll give you all a copy of the transcript. Okay.
Thank you.
Judge, are we not then going to the motion to depose today? You're going to wait until that? Okay,
Because I agree, they should be separated.
okay.
1-3 is 10 days from now.
30.
That makes me feel bad, but we'll do 1-3 and yes. We're just gonna keep moving. Okay. All right, thank you. And then what was your name again, Alex? What was your last name? What is it?
Alejandro.
But what's your last name?
So that's fine. No.
Did you want to set a date for?
Right now, I'm just gonna give the transcript and then, I mean, you can try to set a date, but let's just, everything takes longer than I think it's gonna take, so.
So once we get the ruling, we should call your JA and ask
I
for,
think once we get the date for the ruling, you can probably come up with the date for the deposition.
okay.
For the motion for deposition. Alejandro Silva, and are you also in laws? Okay, all right, thank you. All right, happy holidays, everybody.
Thank you. You as well, Judge.
Yes. So we're all gonna take a brief break and then we're gonna go on to white. I'm sorry, but I am giving you guys lots of days off. What's today, the 19th? 18th. Today, the 18th, that's today. What's that? Nope. We're going to I'll give you guys a half here for Rashad White.
Okay. Yeah, I thought it was the 19th and it was the 18th. So I missed it by one day. So I guess we'll be back tomorrow to find out what the judge decided. So I need to look at the docket and see what time, because she didn't say. So I guess I understand it now. Apparently this to-do list that she had, she wrote privileged on it. Doesn't make it privileged, just straight privileged on something, and attached it to an email that she sent to the Clenneys. Stupid. Why did she do that? What she's saying, I don't know law, so I don't know if she's correct or not, but I've always heard that you have privilege between you and your client. When a third party's there, there's not any privileged. I don't know if that's correct. I mean, she's the lawyer, she should know, but if someone else is paying the legal fees, are they allowed to sit in? Does it stay privileged if they like sit on meetings and stuff like that? I don't think so. And yeah, you're right. Just because she's an adult. They're not her legal guardians anymore. Just because they're footing the bill. If it was, it would never be me. But if it was me, because, okay, you guys may not like this about me. In 2010, when I had to quit working, when I got really sick and had to start trying to get disability, well, before 2010, because it took me like 2 years. So it was 2008. I went through all of my retirement money, all of Travis's retirement money, and we were flat broke while I was waiting to get my disability approved. My dad helped us. So, and he paid when I got out of high school, he paid for my LPN school. When I went back to school to be an RN, he paid for that. Vacations I took, he paid for that. Friends, he paid for me and friends and himself to go with us sometimes, to go to Disney, to go to dinner theaters, to go. He paid. This was a birthday present. Paid for me and my best friend to go see Billy Joel. That was just my dad. He liked to do things for people, to see them enjoy it and be happy. And he had the money and he could do it. So, and I know a lot of people are like, adult children shouldn't take money from their parents, blah, blah, blah. But that was just my dad. That's the way he was. He insisted. In fact, after my mom died, he got really sick. And so I lived at home with him for a really long time, like a lot longer than most adults, are up and out. I had my own job, but I stayed to take care of him until he remarried. And he wouldn't let me pay my own bills and stuff. So I wanted to help pay the electricity. He wouldn't let me. He wouldn't let me pay the phone bill. So I got my own phone because he wouldn't let me. I said, just let me pay the phone bill. No, you can just pay for your long distance calls. I'm like, no, let me pay the phone bill. So he wouldn't even let me pay. I would beg him, please let me pay. And he wouldn't let me pay. So anyway, if it were me, what I would do, I would go to my dad and say, look, I need this much money for my defense. Although my dad wouldn't have had that kind of money. But I would say, I need this much money for my defense. He would give it to me. Well, why? And I would tell him why. He would give it to me. And then I would tell him what the attorney was doing. But I wouldn't, because I wouldn't want to screw anything up by having him be in the meeting or him talking to the attorney or whatever. Because then that dissolves privilege. I wouldn't want to put anything at risk. I would want to be just me and my attorney. And then I would talk to my dad about it later. So I don't know why they're being considered as part of the team or whatever. Like the prosecutor said, Team Courtney. Like, I don't think that's right. I mean, I don't know if it's legally right or not, but I still don't think that's right. Because all they're doing is paying the bill. She's the client and she's an adult. So I think anything that's said in the presence of her parents shouldn't be privileged. I could be wrong, but I don't think it matters who's paying the bills. I think if it's anybody else is there, it's not privileged anymore. And those lawyers, they have been on so many court shows already. Like, they're just yakking it up. So they're not holding much back. The man does not understand that I am busy. Geez. So, I mean, it's her own fault. Like, now she's trying to get the judge to clean up her mess. You know what I mean? So, I don't know. So, I guess tomorrow, because I have to call Travis back right now. So, tomorrow, I'll look on the docket to see what time it starts. And I guess we'll watch the hearing tomorrow. What did she say? There was something else. Motion to oppose something, I think she said. So we'll look at that tomorrow. I don't know what happened with the camera. Like, okay, first off, I don't know why they did it Zoom, because everybody was there in the court. And then the Zoom feed switched from being one square of the judge and one square of the attorneys to being both squares of the attorneys. I want to know where they got these camera people. I hope they do better when the trial actually happens. And I wish they would name a date. I want a trial date for this. Because I'm probably going to end up having back surgery this year, and I need my calendar filled out so I can know when to schedule my back surgery. I need to schedule my back surgery around the trials I'm doing this year. Okay, guys, I'm just rambling now because I like hanging out with y'all, and I don't have anything else to show you. But I do have to record an episode. So I'm doing a review. I've not done this before. I've always pulled from a whole bunch of different resources to give you guys true crime stories. I am doing a review of a Netflix documentary this time. I'm going to tell you guys about the Netflix documentary, the new one about JonBenet Ramsey. So I'm going to record that when I get done with this after I call Travis back. And I'll see you guys tomorrow. So, and Judy, if you don't... Okay, bye. Judy, help me find out what time that hearing is tomorrow. See you guys later.